Yeah.
Yes.
Please,
Yes.
may I be permitted to mention item number 5? Item number 5.
Okay.
So some subsequent development has taken place, which what I seek for the week time.
Mr. Kato is there? No.
Marco, my lord, is the main respondent. I'm appearing for the deputy commissioner, my lord, who has no any role to play, my lord, in this case.
I'll wait for the item to come, my lord.
Huh?
I'll wait for the item to come, my lord. Item to reach. If Kato is not available.
Just wait for some time. He's not there.
Lodge.
Just wait for some time.
May I please, madam? Madam, here some madam inadvertent mistake in court of matter. Madam, I have madam inadvertently not added the madam respondents who were parties before the madam tribunal madam. I may be allowed to madam make a proper application to make them necessary party madam.
On the ground that all parties to the proceedings before the tribunal are not arrayed as respondents herein. Mr. R. Saidia, and counsel for the you're for Union of India.
Yes, madam.
Your designation would be
Madam, listening counsel madam.
Listening counsel for the appellants, sorry, petitioners. Please for impleading those left out parties. There's a small issue.
Madam.
When you implead parties, then the presentation of appeals, so far as they are concerned, would operate from the day you implead them. Then your this petition to challenge the order. Is there any limitation prescribed? No.
No.
No limitation is prescribed.
It's a repetition, madam.
We understand, but is there any limitation prescribed?
No.
It is submitted that as the order of the Central Administrative Tribunal has been essayed, in this writ petition, even if the new parties are included, the matter would not be barred by limitation. Consideration of this statement, there is a law, the matter stands adjourned today, giving liberty to the leading counsel for the respondents to, petitioners, implead the such parties as they may be so advised by submitting typed out freshly typed out was titled to the deputy registrar with the judicial. So to have it incorporated in the petition, matter be thereafter listed in the motion copy. We are issuing a notice in this matter.
Yes, ma'am.
But which I am able to counsel for the petitioner. in this, yeah, it is projected that funds amounting to rupees 11, 82, 00, 000 was sanctioned for construction of 12 community halls under CD- block Parsi, PARSI, Parlo, PARLO, Purum Pune district at 12 locations. Projected that the contrary to the terms of the tender, as well as the envisaged project, there is an alteration of site by replacement of official geo-tagged GEO-TAGG tagged site. It is also alleged that the quality of construction is below the project as envisaged in the detailed project report, within like a DPR for short. Next, in this regard, comment is submitted that the petitioner has annexed the photocopy of the official geo-tagged site as well as the present site where the constructions are being made. Further submitted that on an earlier occasion, the petitioner had approached this board on the ground that the application was premature, the PIL was closed with liberty to the petitioner to approach again, right order dated 29/1/2025. Past in which page is that? We had 3 of 2025. In view of the projections made from initial notice. Returnable in 4 weeks. Mr. R.S. Nabam done it. Additional advocate general accepts notice on behalf of the small numbers
1, 2, 3, and 4.
1, 3, and 5. Mr. D. Richard done it. Standing counsel for the Rural Development Department accepts notice on behalf of the small numbers
2, 5, 6, 7, 8.
5, 6, 7, 8. So now you are also appealing for 9.
9 would be represented by AG.
My lord,
Why
but
not?
in my lord, the petition copy is only up to 8, my lord. There is no 9, my lord.
There is an amended PIL. It is not an amended.
They have amended the cost title.
Give me
Okay.
copies.
They have not furnished us, my lord.
Give him, otherwise he'll not say.
My lord, I think I have punished, sir.
No,
So I don't have that.
no, give it.
Okay, okay, my lord.
Otherwise he can't accept notice. Without knowing who is the party, he can't accept notice.
Matlab, today,
The also I'm reading. So however, the runner additional will be generally submitted that he has not received the amended cost item. Amended cost item, so therefore the runner counsel for the petitioner shall hand over requisite extra copies of the petition as well as the amended cost item to the learned counsel assisting the runner additional to the general. In 2 days. As well as to the picture. As well as to understanding counsel for the other rule development in 2 days. Next. Joint Director from our Rural Development Department. Within bracket, respond number 6. Will conduct a inquiry regarding the site, the constructions, the proposed construction of the community halls are coming up. CD block of Kurun district. Sorry, CD block of RC part of Kurun district. And the report of his inquiry, along with the originally geotyped site, shall be provided to the Donetsk County Council in a seal cover for the perusal of the court. Next, the petitioner shall take steps within 2 days for service of notice on the respondent numbers 10 to 17 by registered post ED. The County Council for the petitioner is activated, shall correct the postal receipt number and submit postal track report to the registry prior to the next date of testing. Make it returnable, the date after 4 weeks. Making it a returnable on so.
Let it be after 6 weeks, my lord, because my lord has directed us to make an inquiry.
12 places, 12 site, how much time will it take? If they take a vehicle, they'll do it in 1 day. Geotagging is most easiest thing.
my lord, inquiry has been continuing last many times. The inquiry was, this was already instructed, but that was not support, and this has been already 3 months now.
If on the name of inquiry, you are seeking more time. Then Mr. Picha, in the mind, the first thought process is दाल में कुछ काला है. No, it's just a thought process. I'm just sharing it with you. No, okay, we make it 14. Okay, we make it 14. We are giving you time. 14, 5, and 5. Just next class, before last time, you say the respondents are put to notice that in the event the site where the construction is carrying out does not match with the DPR. The respondents would also reply to shall also respond by way of an affidavit as to why orders should not be passed for staying of the ongoing work. This concerns.
Compliance matter.
Mr. Pichar, just say, Mr. Pichar, just add one more line. The standing counsel for the Rural Development Department shall send a downloaded copy of the order to the respondent number 6 to bring the order to the notice of the settler. Yes.
Mayor Lordship, Your Lordship, as per last order, we have communicated with the petitioner and she's out of station for now, so we may seek some time to file the affidavit. Your Lordship, I may like to praise a few things here. As per the affidavit filed by the respondent number 3, in point number 6, they have mentioned that for construction of solid waste management plant, they will take 2005 to 2006. Within that, it will be operational. But it is not concrete that it will be complete or not. So within that time frame, maybe they file a status report. So it will complete within time.
Affidavit of respondent number 3. Which page you are saying?
It's page number 54. The affidavit filed by respondent number 3 on last occasion. It starts from page number 53, last para, page number 54, first para. Since our aim is to clean the environment, not just to clean the city, so it will be better
No,
to
respondent
speed
number
up.
3 has filed an affidavit on 31st of January. 54, 52, 53
53, 54.
doesn't match. Affidavit filed when?
On last occasion. Additional affidavit filed by respondent number 3.
Respondent number 3, filed on 4/4/25.
Oh, yes, got it.
Page 50.
53 and 54. 53 para 6.
Something is wrong, it's not matching. Show us your page.
It's 53, Your Lordship.
Show the page.
Different is different.
Page
This one.
Page 15.
This one.
She's looking at page. Number is 15. These are-
Oh, yes.
No, the page numbers are different here.
Now it's page 15.
Now page 15.
Actually, we have received this.
It's okay, you make marking according to the code. You may have received first. But there are two issues in fact. Number one, according to the law which is holding the field, please tell us jurisdiction wise, once the area is an urban area. Number two, the area is a small town area where there are municipal boards. And third category is panchayat areas. Which is the law holding the field in these three categories of places? Urban, where you have municipality, not big cities where you have municipal boards. Or third area where there are panchayats. In respect of this air pollution, which is the law holding the field? Huh? You probably were attending for the state. You are attending for this urban bodies.
They know where area and where is my area. Sort of these people. Last time there was a very pertinent question regarding the third catered in the event of Canada. I remember. So I immediately connected to them and asked them some there be a doesn't come in the jurisdiction of the identity. So
The jurisdiction of?
It's only thing when you say.
That is outcome jurisdiction. So we cannot operate there.
This because you see what is happening. Just like Mr. Jam said, it's beyond jurisdiction. So if somebody can't work, so now we'll have to rope in all these authorities of different jurisdictions. This panchayats and all, they are also be required to be impeded. So instead of impeding the panchayat department, every panchayat area in the state, we will impede the panchayat department. Who is looking after panchayat department? Panchayat Raj institutions. Who is the authority looking after panchayat Raj institution? Secretary Panchayat is there. Director Panchayat is also there. Is Director Panchayat a party here?
Last time, or learn it. Little brother was there, but. Election commission, or election, yeah.
You are appearing for the State Pollution Control Board. Do you have any segregation policy that you will look after urban pollution, you will not look into the what you call panchayat level pollution? Is there anything like that? Means if supposing I am a what you call antisocial element, I start polluting industry in a panchayat area, then does that industry goes outside the purview of Pollution Control Board, Arunachal Pradesh? Here, if I do in the neighborhood, then the Itanagar Municipal Board is there. Panchayat, your Pollution Control Board will come and say that you are polluting in the town area. Now, if I shift a polluting industry to a panchayat area, will obviously no, that does not say so. The Pollution Control Board is for the entire state. It does not have department-wise approach that I'll operate X, I'll not operate in Y, I'll not operate in Z. Correct. So when Mr. Jamo says that one part is covered by the Itanagar Municipal Board, and where there is actual dump or this plant for garbage disposal, in the highway when there is all garbage dumped, then the municipal corporation says outside my jurisdiction. I'm asking you, that's why, if that is not an urban area, not covered by municipal, does the Pollution Control Board keep its eye open? Or it is not bothered? No, you see, Ms. Vamno, it's very difficult. You'll have to take all instructions and this is a PIL number 1. Correct. Every time we may have a different question. When the matter is taken up, if it is taken for 210 days in a year, in 210 days, we can have 210 questions. To answer every question, you can't take an adjournment. Because what we don't like, we'll have to do. We'll have to ask these officers to be here. When this, especially this pollution matter in the in garbage disposal is being taken up. Otherwise, everybody starts passing the buck. You've seen Mr. Jamo, he has said that it's not an urban area. Itanagar Municipal Committee will not do anything. Now that for every place you'll have to search out who is the department behind. This PL will be never ending. No, no, initiative, you can ask anybody who will give very good lecture. If you get hold of any big, what do you call, IAS or APS officer, they will give hours and hours of lecture for initiative taken. But we want it clean. We want the city to be clean. We don't want sermons on initiative taken. In those initiatives taken, please tell us what has happened. Which road will I walk today where I'll not find a garbage? Indicate me one road, except yes, Governor's place and Chief Minister's place and the assembly sector. These three places you set aside and then tell us which road should we walk. In fact, today after the potas, I'll go. Which stretch of road covered by this PIL is not having garbage dumped on the road? Your issue of initiative fails. Number one, somebody is filed an affidavit who's saying that we have put up garbage bin. Second authority comes and says that there is a garbage bin, but people don't throw garbage in the garbage bin. Third authority has filed an affidavit saying that these garbage bins were stolen. Now, what should we do? The state is not expecting us to make inquiry against every dustbin. We can't say that you employ policemen to guard, have an armed guard for the security of the dustbin. What should we do? We're just asking, apart from these three places, one road where we walk and we don't find a garbage. You will resume again, the division bench will sit again at 2 o'clock for this purpose. We ask these people and tell us. Two authorities, we want an answer. This Pollution Control Board, whether they have any jurisdictional issue for the, you can pinpoint the place where the garbage dump is. It's not a, Mr. Jamo says it is not a municipal area. And who will look after that pollution? That's the first answer we want. Second is, there's an affidavit filed here. That's why we are asking that question. In that affidavit, when Itanagar Municipal Board went to collect garbage, the people of that area protested. They said that it's a panchayat area. And thereafter, things escalated and the deputy commissioner had to have a meeting with those panchayat people and then gave a statement that the municipal corporation will not collect from the panchayat area. Now please tell me, if this panchayat is not collecting garbage, now what can be done? Non-collection of garbage is not an offense, you can't arrest them. Non-collection of garbage is not even an offense which is punishable with fine. You can't do it. Now, how do you enforce it as a pollution control board? How do you enforce it? That garbage has to be collected. You're not finding any answers. You see, the first initiative would be You don't have to go very far. You go around this complex. Correct. You may find that people who are sitting in few table, even their own table is not dusted. I have visited this and then I am telling you. I have visited the sections. There is dirt in the tables of the sections. And we have not been able to instill the basic culture of the people to just clean the table and then start working. I've done it. So if people are not cooperating, how would you collect garbage? People will throw garbage when nobody is looking. How will you see that? You can't have CCTV not to detect crime, but to detect garbage. You don't have any answers. Your initiative taken is not translating into something which you see in field. Or we give you another option. There's a TV program where you have phone a friend. Ms. Wangmo? Ms. Wangmo? There's a TV program where contestants have a option to call a friend. You've seen that TV program, I believe. Kaun Banega Crorepati, you don't see. Now you can, instead of calling a friend, you can turn around and any learned counsel sitting here. You ask them where they reside and whether in nearby their places there is a garbage which is not collected for days together. Phone a friend. We will ask one of the most respectable lawyers here, Mr. Apang. Around your house, there's no garbage which is remains uncollected.
So far, my area is concerned, sometimes I sweep the main road also. So my area is okay.
Oh, very good.
My area is
Very
okay.
good.
Rest I do not know, but my
Oh,
area,
very good.
since it's a VIP road. So, today also it came.
Okay. Okay. So where will you succeed now? At 2 o'clock, we'll take it up. We'll resume for 5 minutes. You tell us how does the pollution control board oversee when there's a dispute with regard to jurisdiction? What is the law applicable for collection of garbage insofar as the municipal areas, urban municipal areas is concerned? And number two, the panchayat areas are concerned. And number three, small towns where there is municipal boards. And we'll include this authorities, which is the panchayat department. You take instructions as to how the pollution control board envisages. What is their plan for this garbage? 2 o'clock will resume for some time. The division bench. Issue, Mr. Jamo, in this matter, one of your affidavit says that you have the door-to-door garbage collection, but then you also say that your garbage collecting vehicles are off-road because of certain technical or mechanical issues. And then you also say that at times the drivers have take leave for certain reasons. And there's one more reason you have assigned why the garbage collection cannot work. 3 reasons you have assigned. Now, please tell us Do you have an alternative plan?
My lord, last year.
No, whenever, that's okay.
Employment, the
But twice, what you call, the court staff says, I was just cursorily asking them. There are many court staff who say that they don't find 2 times garbage collection. Which area you'll have to tell us you're doing it, because generally people say that twice a day it doesn't work.
where advantages are, we run to.
No, where is a very difficult task. Where there is garbage is a very difficult proposition to understand, because garbage is everywhere. You must have a plan in which places you do it. Everywhere there is a garbage. You must tell us the routes in which this twice collection is taking out. Because then it doesn't, your first affidavit, you have not altered that, you have not explained this time in the second affidavit, that the vehicles are now being utilized. There is no day when the vehicles collecting the garbage are out of road. Or the third thing you said was that on Sundays and holidays, we don't collect. That you have not altered in your last affidavit. Because then, if these 3 reasons are assigned, and then you said that twice we are collecting garbage, it appears to be inconsistent. Because you are taking care of holidays first. You are taking care of holidays first. Sundays and other holidays you don't work in the first affidavit. Then you say that at times the garbage vehicles are out of road for reasons, 2 reasons you are assigned. Staff take holiday and garbage vehicles have mechanical failures. Then the second affidavit saying that you collect garbage twice, we think it is inconsistent.
And we take instruction, right? We have more about intern plan.
Pardon me?
Regarding the query of session, that's we have not been informed about it. But we will take the step right. If they have any regarding 2 times members, then
You reconfirm it. You see, we are saying that it is inconsistent because of the fact that in the first affidavit you have said that you don't work on few days. Then how is the second proposition working, that you are collecting garbage on 2 occasions? But then you'll have to say that we collect garbage on 2 occasions on these days, and these following days are non-working day. And therefore, we must show the plan, because you are in the plan sheet which you have given. In that plan, you don't have those holidays and all accounted for. That's why we are saying it is inconsistent. At 2 o'clock, we'll sit for some time again. Yes. Yes. Huh? When? No, but you see, this is a case where your delay will not be is not acceptable. The petitioner said that he has suffered incarnation of above 25 years.
I have got only verbal instruction.
Huh?
Till now, I got only verbal instruction, verbally. This morning, I spoke to this Commissioner Home, and he instructed me to inform the court that his case has been considered. It is approved by the government for release of person.
Remission approved.
Approved, yes.
Okay. Because now Supreme Court is taking up these matters.
Yes.
In fact, they are directing the high courts also to take it up on day-to-day basis. On the issues of the incarnation of more than usual life sentence. Okay, 3 days time, then we give it to you. 3 days time, and we'll take it up at 11th. And this and then transfer for the petitioner. Stan Luang Leonard, senior government advocate, has submitted that he has received instructions and the affidavit in opposition is ready, which will be filed within 3 days. So, on the query of the court, next on the query of the court, the Leonard senior government advocate has submitted that. So instructions received by him. The steps favorable to the petitioner has been taken by the state government. Next paragraph. Because it may, magistrate's adjourned today, list on 11/4/2025.
Lordship, if I may, there's something I'd like to point out. The petitioner, the person who's incarcerated, his name is Kodat Tagia, not Tabang. But for some reason, I had filed this in this name, but for some reason it has been listed as Kodat Tabang. Tabang is the person to whom he has been authorized since he's incarcerated. Is the person who has filed the affidavit on his behalf. I think there was some misunderstanding with the registry. Tagia is the person, the petitioner.
No, but you see why it is happening.
Yes.
Is that normally this is not filled up by the registry, the first page.
The first page, Lordship, we filled up as Kodat Tagia.
The first page of the order sheet is filled up by someone. They are not part of the registry.
Okay, Lordship,
Here you have given the name of Koda Taban
Lordship,
in this first page.
Lordship.
Correct.
No, that we have not filled up, Lordship.
Okay. Next one, the ground counsel to the petitioner submitted that as per the cost title, the petitioner who is currently lodged in the district jail is Sri for the KHODA for the Tagia, TAGIA. But the registry is incorrectly referring to the petitioner as Sri Koda Tabang, who is only the person authorized to serve the affidavit. As the petitioner is currently in custody, in judicial custody. Next part, accordingly, the registry shall alter the make alterations in the first page of the order sheet and also correct the central registry to reflect the name of petitioner as Sri Koda Tagia instead of Sri Koda Taban. So the correct name shall be mentioned because this by listing the matter next session.
Obliged.
Item number 5.
Yes, nobody is there, Mr. Kato is not there.
My lord,
Oh, yes, you're there. Yes,
that's-
he is paying for an adjournment.
My lord.
No objection? Okay. Mr. P. J. Sekal, Senior Counsel, assisted by
M. Nirula Lordship.
M. Nirora, Learned Counsel, submits that as per his instructions, some development has taken place for which he needs some instructions. So accordingly, on his plate, the matter is adjourned today. Next, Mr. M. Kato, and DSGI is present. This is the matter after. So say here.
after a week, my lord. In the 4th week of April,
The week commencing 28/4/2025 on a date to be fixed by the registry.
My lord. Biplab.
obliged.
Item number 6.
May it please the lords. My lord, will recall this is the PIL, my lord, directed against the lack of progress in the construction of national highway. Now, my lord, in terms of lordship's order, the department has filed an affidavit, bar chart and all. They say around 37% of the work has been completed. Thereafter, this honorable court wanted that the representative of the respondent number 7, that is the primary contractor, should be present. It was fixed on 4th of this month. 4th, my lord, this honorable court did not sit. I found that they have filed an affidavit saying that they were present on that day and they are not able to appear today.
Meet please, your lordships.
The affidavit, my lord, filed by the principal contractor is full of excuses, my lord. This road, my lord, stretches around 11 kilometers. The flyover is only around 3.9 kilometers. Now, as far as the 4-laning of road from a place called Model Village up to Nirjuli, there is no encumbrance, nothing, my lord. My lord, I filed an affidavit reply showing the state of it also. It's absolutely, my lord, in a condition, my lord, I cannot say that Nirjuli to Model Village to Nirjuli part also. Flyover, I understand maybe there was some problem, it goes through the middle of the town. But that part, my lord, I understand the executive engineer is also here. We don't know what is going on and in that part at least. For some construction, it is so deliberated now, it's everything has gone better.
Me?
The road part from Model Village to Nirjuli, that part.
Yes.
There's no encumbrance there, my lord. This should have been, at least that should have been constructed, man.
Yes. Mr.
Meet
Dubey,
with the
you want to
lordship.
say something?
Yes, my lord. My lord, in fact, your lordship was pleased to direct the personal appearance of the authorized person, my lord, by an order dated 12/2, my lord, and the date, 27/2. On the 20th of March, my lord, the authorized representative was present, and we also filed our affidavit, my lord.
On
And
that
then,
day.
my lord, on 20th, yes. And thereafter, the matter was adjourned to 4th of April, my lord, last week, my lord. Last week, my lord, the authorized representative was there in compliance of your lordship's order, my lord. And my lord, we have also filed, since your lordship's bench was not sitting on that day, my lord, we filed a affidavit of compliance, my lord, indicating that the authorized representative have come, my lord. And we,
Uh, in this, who will be able to tell us that in the span of this 1 month, what would be the because whether the work done has achieved any milestone or not, or whether the in simple language, whether there is any progress in the work?
My lord, that's why, my lord, we have said, my lord, as per the bar chart submitted by the contractor, my lord, and the progress of the work as per the executive engineer, my lord, the status of the work which has submitted. There is progress.
There is progress.
Yes. Otherwise, my lord, in progress, they are saying, my lord, is there was filed in
That is page
February.
83 affidavit.
Yes.
That's page 83.
My lord will see there are 149 pillars. They themselves say 37. Half constructed, not even constructed, my lord. That pertains only to this flyover part, my lord. They are not even replying as to what happens to the four laning of road from Model Village to Nirjuli. That part they have just left aside. They are not even replying to that.
You remember that Google incident? Somebody took a drive looking at the Google GPS map and dropped down in a river
My lord.
from a bridge. They dropped down into a river. It was an incomplete bridge. You remember that?
No, man.
3 months back was the incident.
Yes.
Yes.
Google Maps. An incident
The
took
bridge
place.
was half constructed.
Huh?
The bridge was half constructed.
Bridge on a river was half constructed.
Yes, yes.
Google showed
But
is
the-
complete.
Oh, yes, yes.
And
And this will be the case here, my lord. One person, my lord, in fact, fell into the pit and died here in Nahardhagan, man.
no, this will maybe
Since it was supposed to be completed on December 2024, maybe Google shows it's to be completed. And my lord, the takeoff point starts in a place near, is a place called Papunala.
you've seen that we have gone
Nothing is there.
there. We have gone there. Last time we told you
Yes.
when I and Justice Kavita was there, we went in the evening to see that on the day.
Absolutely nothing.
Not there. You
And
see,
now also
please
nothing.
come to page 83. This is the affidavit filed by the senior advocate for respondent numbers 1, 2, 3, 4, 5, 6. This is October 2024. Milestone 1.
There is a affidavit.
10% of CP. What is CP?
My lord, there is an affidavit filed thereafter also.
No, that's okay. We're going one by one.
Well,
What is 10% of CP? CP means what?
my lord, the executive engineer is here. My lord. Yes, well, page 83, contract price.
Contract price. Contract price is not a milestone.
Yes.
That may be a milestone for a contractor. But if for a general person who wants to use a road, milestone will be the progress in the construction of road. How much you pay to a contractor is not a milestone.
My lord, which affidavit dated?
This is an affidavit on 25/10/2024.
In terms of the order 26/9/2024.
35%, second milestone is 35% of contract price.
Yes.
It's not achieved. Mr. Ratan, is a simple question. I'm reviewing it very simply. There is a festival today somewhere. I've been invited as a guest. In the morning, I went to the tailor for a suit.
Yeah.
And today he gave me delivery of only a coat. And says that, sir, you can go, we have 50% milestone received. Down below, you can wear a half pant. 50% milestone achieved, please go there in the party.
Oh, yes, my lord. That cannot be, my lord, contract price, the milestone on the basis of contract price.
Then the work is over. You can make overpayment and the work is over.
In any case, my lord,
Contractor will do 10% work. Your authorities will make the 100% payment. And say that project is over.
my lord, in any case, my lord, we have subsequently, there is a bar chart prepared by the contractor and that was placed before this honorable court. And
Bar chart would be first prepared, given it to the authorities, they will approve it,
yes,
and
madam.
on the basis of that, it will progress.
Yes, madam.
So
Now,
what is the approved bar chart?
yes, approved. In terms of that also only 37%.
It's okay, let us see that.
That too in respect of the fiber only they are saying.
There's one bar chart in page 151.
Yes.
Excuse me, what is your designation? Executive engineer. I'm just looking at page 151. Since I don't know anything about construction, I'm asking you.
This was the earlier.
In the,
This is earlier. Madam, this is the earlier bar chart.
in the first part, no, whatever it is, I'm just trying to understand. In first column 1, row number 1. It's a construction of new 4-lane flexible pavement. Brown color is work completed. So you have completed this up to July 2022, January to July. Then from May to August, you are showing a monsoon. Then you have this multicolored, which is monsoon but working. And this is working period. Now, item of work is earthwork up to the subgrade.
Not work up to the subgrade.
We'd like to know the technology you are employing when you are doing the earthwork. In middle of that, there's a monsoon. How do you retain the earth? I'd like to learn this technology. Yes, yes, please.
So you can see, my lord, you can see from January to April, artwork, we are doing the artwork. In the meantime, if you come down, we are doing the sub-base course also. Sub-base course, next column.
Yes, sub-base course.
Yeah, parallel course. Sub-base course, then we go for next layer, non-bituminous layer.
Yes.
So the subgrade portion is covered up during the monsoon period.
But sub-base course,
Yes,
is
sir.
it not filling it with the stone?
GSB, then a little material. So point is to cover that prepared sub-base course, my lord.
I'll tell you very
Real-
simply. When an embankment is made, this is when you are building a road, it's sort of the first is yes key.
Right.
If we have traveled this road many times. Your footpaths and all are broken.
Right.
Correct. Now, if you don't have a written mechanism, even if you store, when you place earth and top it up with what you call metal, when the rains come, the subsoil will wash away. Therefore, when an embankment is made, the first requirement would be to have some, otherwise this washes away. That's why when you are, the next part you are saying that the base is there. And this, you see, when you're showing a bar chart from this page 151, from January 22 to December 22, we perceive that this is for the entire length of the work.
My lord. See, my lord, we come to serial number 17. So this is the retaining wall
154. Page 154.
154,
174,
serial number
54.
154.
154. So we go to serial number 17 where we have a provision for retaining wall. So you can see, my lord, simultaneously retaining wall has to be constructed to retain the earthwork.
But is this, if we travel from this left side to right side, this cell number 17, the observation is it is a retaining wall. In a road, we're trying to understand in this stretch of road,
Yes.
except for that two nala. One place there is a market, there is a big drain. An elevated part where there is a market in one side. That is an elevated bridge. And next, the nala is the Papu Nala. Where else do we have this retaining wall?
जो मेन प्लेन एरिया जो बेस बनाता है उसका ये नहीं होता प्लेन
Which is road. Okay, plain roads. My lord, all along the project lane, we have the side drains. So side drains in a level road, it naturally plays the role of retaining wall. Like this.
Okay.
It goes like this.
So that is your retaining wall.
No such retaining wall. So retaining wall are generally provided where there is a backfill or earth has to be retained, my lord. Fine. So in those areas only we provide a retaining wall. Rest there where there's a earthworks plane, so a side drain acts as an toe wall that protects the formation. Yes.
We accept it. We're just trying to think aloud. Because the nature of retaining wall you just said. I'm just trying to understand from the Borum Bridge, from where we normally enter into this place. From there to Nadagun, that our old High Court complex, this is the stretch we normally go. My sister went a few days back when she came here to just look at the High Court building. So that is a road we usually take. Right. We are trying to, the helipad area, we cross it and then go to the other side, and then we travel from Trims to the old High Court building. So in this stretch, we are trying to imagine where this retaining wall would be.
There are certain areas like the Nada Pharmacy. So all along that there we have the cross drain, culverts. We have a side drain, side retaining walls that acts as to control for to retain the soil. Nada Nada Pharmacy juga. कुछ incomplete हुआ है, we can see it हो ऐसा नहीं चलेगा ना चलिए बस हाँ ट्रेन ही होगा, नेचुरल क्रॉस स्लोप होगा, ट्रेन भी पानी
estimated time of completion is 6/12/24. So has it been extended?
Excuse me.
Extended.
Estimated time of completion according to this document is 6/12/24.
Right.
So that has been extended.
It was,
Extension.
yes, provisional extension was given for 96 days up to 13 March 2024. Now this one, EPC contractor has applied for EOT, extension of time, revised extension of time.
Revised extension of time applied.
They have applied and we have written back with some observations.
So we'll tell you the difficulty in understanding what you are trying to now show. The difficulty in understanding is that if I want a road, and when I am saying I mean the public, general public. General public, what requires is a road. Now, with this sort of bar chart, where you give a idea that we'll do earth filling and this earth filling is done, and we have got no way to understand from this bar chart as to which stretch this bar chart is intended for. So it can be very big as it is. It can be from here to Nijuli, from that, what you call that, Papunala to Nijuli. It can be a small stretch, just like you said that there's a cross drain section and then you have a retaining wall. So unless, number one, it is not within our domain, to understand actually where you intend to create what. In simple terms, what we want to know from the bar chart is there a consolidated bar chart which will show that the progress, let us say from this Papunala, this is 0.00 kilometer. From there you go to Nirjuli, it is 10.00 kilometer, assuming it. Now we want to know from the bar chart as to the progress of work in terms of this kilometer chainage from 00 to 10. And then we understand what work is being done in the road. Second, what work is done for the purpose of this bridge. Because if I am to do some construction, let's say if I construct a room in my house, not construct a room, it's repair of a room in my house, and ask the mason the first thing, how much time it will take, how much material you need, and how much escalation can be expected. Extension of work can be expected. They will start by saying that we'll do it in 15 days. And then I make the calculation that not 15 days, it will take one month, 15 days. When I allow a mason to enter my house, this is the normal calculation I make. In this case also, we want to make the same calculation. As per your engineering terms, it will be very, very difficult for us to understand because we don't know the location-wise bar chart. Therefore, we will not be able to understand. Therefore, please try to get a bar chart of the stretch of construction which is going on from Papunala to Nirjuli, so that we understand the progress of work in kilometers in chainage system, and we know that this work is done. Because Mr. Pangi has made a very good categorical statement that in one stretch of road from the tri-junction to Nirjuli, there's no enforcement, there's nothing, and but there's no progress of work. So this is what we understand. We are not technical persons. I'm a commerce graduate. So please, I'm making it very clear that I am not a technical person to understand. What we are asking you is based on the judicial experience we have gathered when we deal with these constructions.
At least in 5 parts, my lord.
Whatever is there, it will depend. He's an executive engineer. We don't want to impose ourselves and say that this is how you do it. It is in your wisdom. We have just told you the parameters we want. It's a ultimate blacktop road from Nirjuli to Papunala. 2 ways. So this, and there's a bridge in between. So we want to have this idea of how you are envisaging a construction, because we need the end product. We need a road to walk. Last time we shared an experience when I and Justice Mridul had gone to visit this road. From that, in many stretches of the road from this bridge, helipad road we travel and then we reach that side. From there to High Court, many places the roads were broken, footpaths are broken. I don't mind splashing water on a male gentleman, although I should not do it. But inadvertently, despite the car being driven very slow, water was being splashed from my car to few ladies who were crossing the road. And they had no way to protect themselves because the footpaths are not there, it is broken. So as simple as that, we are asking you, number one, do you have a plan? If you demolish a existing footpath, what is your plan for the pedestrians? Number two, if you don't have any plan to expedite the construction of a footpath, then why break it? At least give me some space to walk. Roads are not only meant for people who have cars. Roads are also meant for normal pedestrians. Please take care of them. They are the people who are the lowest strata who are walking on the road. They are compelled to walk for two reasons. Number one, high traffic, they can't take car everywhere. They are compelled to walk. Second is that some people don't have a car and therefore they are compelled to walk. We don't have a robust city bus system here. That's why we are asking you, when we are entertaining this PIR, the intention is to very simply understand your plan to do the work, which includes a footpath, which includes a blacktop road, and which includes a flyover. Right. So the benchmark or the bar chart would be dependent on these three factors. And if the contractor is not willing to do it within the timeline, I'm sorry, I do not know your name.
Tajang, Hagi Tajang,
Tanjan.
Hagi Tajang.
You see, you all see good things in life. Worst things we see when it comes to the bench. We look at murders, we look at anti-corruption, we look at all the bad phase of life we see. So the first presumption we draw is that the department is interested in cost escalation for the contractors they are handing out. That is the first impression. Maybe it is wrong, horribly wrong, but that is the first impression. Why would you pamper a baby who doesn't work? You find no reason. Please tell me if I am wrong. If I am wrong in that thinking, please tell me. I'll correct myself.
Those only the both in there. Yes.
We two of us, we just need a road to walk.
But as suggested by you, since contractor is also there, let both of them sit together and then finalize a new bar chart. So from showing at least in 5 stretches and the whole 10
What
kilometer.
is the 5, 6? We don't know because we are not imposing ourselves. We don't know the
And
realities of our construction. We don't say anything. It is your wisdom whether it will be 4 parts, 5 parts, 6 parts. It is dependent. We are leaving it to you. But
So
we
as
want
to be-
understand
Something
the-
which a layman can understand.
yes. This
portion to this portion,
because,
the flyover portion and the remaining,
Flyover portion, the blacktop road and the drain.
yes,
Sorry, the footpath.
Yes.
footpath.
You were saying something?
That's when what, well, we see it every day. The flyover is supposed to start from Papunala. Papunala up to this bridge, my lord, Borapane bridge, nothing is done. So there has to be one part. Why they are not doing anything there? We have no idea, man. Thereafter it starts. The pace of the construction is, my lord, unbelievable. There are, say, 5-7 laborers there. Every night they are doing it one post, my lord. It will take years to complete, man. We see it every day. Now, one thing is, my lord.
You're right. That is the impression we have.
Yes, my lord. May I point out one thing, my lord? The principal contractor that my learned friend Mr. Dubey represents is sitting pretty all this time, my lord. Now he files an affidavit, says that he can't appear before May, my lord. My lord, let him appear once this break is over, my lord. And let him be here.
Let it be
At
made,
least
let him- let
tell
him
this
be-
honorable court and all of us what he proposes to do. What I have understood, my lord, he is the principal contractor. He has sublet the work to one company for the flyover. Some portion to TK. What is the principal contractor doing, my lord? He is subletting all the work to everybody, my lord.
I have a different example. Can I
My lord.
share it? In the principal seat at Guwahati, we have 2 lawyers who have largest number of briefs. But we have never seen them in court. And one of them, and both of them are regular, they have regular appearances in all the talk show leading to law. In all these talk shows, they will be there, inadvertently be there. But not in court. There's a viral video of in the principal seat, the lawyers are accusing the judges for shifting of the High Court building. The lawyer who is speaking the most, I've never seen her in court. At least not in my 25 years, I've never seen.
The circumstances in this case, my lord, SA11, what I would understand is the respondent number 7, my lord, he bidded low price, got the contract, and now after taking commission is awarding the work. No wonder, my lord, the work is suffering.
This is the department to think, we can't think to that extent, but yes. You see, we are expressing our dissatisfaction with the progress of the work. And you have disturbed the main Naharlagun town in such a manner
Yes.
that it is really very difficult. We had to pass orders by virtue of some corridor we have made so that car can travel. But that is also now in a damaged condition. We also saw that although there are no labor at all in the entire stretch of road, but these cars, vehicles, all these things are dumped. You see, you can clear those roads so that at least people can do their daily work even in that condition. But you are not making those. It's in a condition where you just. This is only one part. The second part is that you have not treated about the dust pollution you are creating. Kindly see in that stretch of road. What is the amount of dust which we have to face? Can anybody walk in the peak hour in that stretch of the road without any fear of getting ill by dust pollution? Can you think of walking?
And one can, my lord, imagine the soaps there, my lord. There's soaps all along.
Yes, and that's why some people have put in the plastic curtains.
Yes. Yes. There are sweet soaps, my lord. People are eating from there. And my lord, will see just before the tri-junction where we entered the High Court, my lord, the filth and the garbage, my lord, it's unthinkable.
You notice that. That is why in the earlier PIL we were talking about that garbage. We are really disturbed. If you don't have a plan, stop it. You don't want development.
In fact, the Chief Minister in the Assembly said, at this place it will never be completed. I don't know who is responsible. The department cannot also have some approach. They're supposed to have it implemented. Now the contract, we don't absolutely, my lord. This was filed in July, my lord. Till now, we don't have an answer. Why, my lord? There is the delay, my lord. The department is saying something. The contractor does not want to respond. Somehow or the other, contractor is, my lord, not facing the heat in this case.
You'll call them in your office and do it. Call them in your office, please do it because
And on the next day, my lord, let the representative of the contractor also be here before this honorable court. There's already an order, my lord.
no, what we'll do is now, instead of this calling up these contractors and doing it, I'll just discuss with my sister before I pass on.
ज्यादा देने की जरूरत नहीं क्योंकि हम लोग ऑलरेडी डिले हो चुका है अभी जैसे आगे बढ़ाना है और
I can make.
You see, we are proposing that in order to streamline this PIL, we will not hear the contractors because you are the principal employer. The state government is the principal employer. And if we can streamline your departmental approach in the matter, it will work more better than contracts do for us. So contractors is something for the time being, for this 1 or 2 dates, you deal with it departmentally. We don't want to have a commitment from the contractors. We want to have the state commitment to your department as to provide us the timeline, because then we can catch the government and we can enforce the orders. It will be effectively, it can be effectively enforced. And when I say that the writs can be enforced, we really mean it. So we are passing an order directing you to do whatever is required departmentally, have a bar chart made for layman's understanding with regard to the progress of work from the entire stretch, and then present it before us. And we also want your policy decision that if the contractors do not maintain the timeline, what action do you propose? We'll gradually compel you to do it in a manner which is beneficial for the general public. The corollary aspect which we are touching is also how to control this dust pollution between this in the stretch just after that what you call High Court Point. We turn some few hundred meters there and the construction stops there. From that place till this TM's Tri-Junction. What is your policy to control the dust pollution? These aspects we are touching in the order. Mr. Pending and counsel for the petitioners. Pursuant to the order dated 27 January 2025. Shri, Mr. Arpan, please write it so that I don't make a typing mistake in the name. So executive engineer. Within bracket, it will be highway zone.
Division,
Nahalabun,
highway division.
highway division. From a government of Arunachal Pradesh. Also, division from PWD, government of Arunachal Pradesh. It's present. We also heard Mr. Andrathan, the additional advocate general for the state. Mr. M. Katul, and a DSGI. For respondent number 6. And Mr. E. Pai, government counsel appearing on behalf of for respondent 7. Okay. Mr. R. Dubey, and a counsel for respondent number
The way is for 7, man. It's for 7.
for 7. Okay. Along with Mr. R. Dubey, that counsel, please to video conference. Next paragraph. In order to examine the progress of the work, we will examine the affidavits exchange in this PIL. Including the which are available, which are annexed to the affidavits. This one. The learned counsel for the petitioner referred to the filed by the petitioner against the affidavit in position 7. And it is submitted that visually there is no progress of the four-laning of Itanagar to Bandar Deva section of M5 from km kilometer 40 plus 3430 2 km 51 plus 75 within package B. Stated that out of 11.305 km, 352. It's 352. kilometer, which is the total, which is the total length of stretch upon which work is to be executed under package B, the total length of flyover to be constructed is 3.950 km and remaining 7 kilometer is for hold from Model Village to Nirjuli town. So it is submitted that in that stretch from Model Village to Nirjuli town, where there is no encumbrance whatsoever, or there's no progress of any construction work. So it is submitted that in the meanwhile, the PWT authorities are not maintaining that road properly, and at this moment, there are a lot of potholes in the road. And at places there are also water logging. It is submitted that the faulty construction of drains has left major part of the road as unmotorable and in a highly dilapidated condition. It is submitted that insofar as the construction of bridge is concerned, usually during the entire daytime, no workers are seen, and similarly no progress in the construction of the bridge has been noticed. Next para. We have noticed from the instructions dated 23/11/2024 produced by the learned senior government advocate, which is available on record, that certain photographs are shown towards repair and maintenance operations on Itanagar Dash package B, NH 415. The first of the annexed photographs relate to maintenance being done near Julie, Jully, Julie Junction, near Papunala Bridge. Therefore, the said repair does not appear to be carried out on the stretch of road which is referred by the learned counsel for the petitioner. Yeah. Also take a note of the instructions, contents of the instructions dated, instructions by letter dated 17/3/5 to the learned additional advocate general, which is available on record. Then the status report of the construction as on 17/3/2025 is produced. Wherein it has been mentioned that a cumulative physical progress up to 17/3/2025 stands at 40.27%. And financial progress is 37.25% up to 28/2/2025. In this regard, court would like to express that the court is not a technical expert in the field of road and bridge engineering. And therefore, it is very difficult to understand a projection that 40.27% work is completed. Because visually, only out of 149 feet the bridge, proposed bridge, only
37.
37 have been partly erected.
My lord, as informed, now it has increased to at least substantially increased to 56. 56.
56 by how many pillars? How
Out
many
of
pillars?
149 total, 149.
56 pillars. Okay,
56.
56 pillars. As on date. Full stop. Therefore, comma, in a layman's language, comma, if only 56 pillars are partly erected, comma, the road work from what is that point till Nirjuli? What is that point you're saying?
Model village to
From model village to Nirjuli is not even touched. And the condition of the construction of the road from Papunala till model village is also in a snail's space. Come on. The projection of 40.27% of the work is completed is just not acceptable. Therefore, comma, we feel that the data so produced is misleading. So accordingly, in understand the physical progress of the work, the court is inclined to direct the respondents in the Public Works Department to prepare a bar chart to show the physical progress of the work separately for Blacktop Road. This is number one. Number two, progress of the construction of proposed bridge. Number three, construction of drains and footpaths. Stop. Instead of providing a bar chart for various ingredients of the work, a consolidated bar chart should be provided as to the timeline within which a blacktop road would be completed, the proposed flyover will be completed, and the construction of drains and footpaths in the entire stretch would be completed. Next paragraph. The proposed bar chart to be placed before the court on the next date should preferably be divided into a few sections in between the starting point of the construction work, which is said to be Papunala Point,
Papunala, yes.
up to Nijuli for this, for the package in question,
Package, yes.
package B, the package B in question. And separate bar charts should be given for each section on this three, on the three breakup of constructions relating to Blacktop Road, flyover, proposed flyover and proposed drain and footpaths in each section. Next one. Another issue which is noticed from the submission made by the learned counsel for the petitioner is that in the entire stretch where the work is started, there's a lot of dust pollution arising out of the construction activity, as well as for non-maintenance of the road where no construction work is presently carried out. Therefore, we direct the Public Works Department, Government of Arunachal Pradesh, to inform the court as to what proper steps they intend to take so as to prevent any air pollution in the entire stretch of area where the work is to be carried out. And the plan to contain dust pollution. Next. The court also issues a direction upon the Public Works Department, Government of Arunachal Pradesh, to inform the court as to whether they have a plan of whether they have a backup plan to take into account the take into account as to what should be done if the contractors and the principal contractor and the subcontractors do not complete their part within the timeline as provided in the bar chart, which would include a brief idea as to whether the department has have taken previous sanction from the government for price escalation if the work is not completed within the timeline, and as to what would be the extent of granting extension of time for completing the work without considering any price escalation. Stop. This part of the order does not mean that if they don't have a plan, they will implement it. They will do the exercise now. So, but if they don't have a plan, they would file an affidavit to inform the court that they have no plan. So, then the another question would be that by which time they would make a plan to examine that aspect of the matter. Next paragraph. Had we passed an order earlier to tell us to whether there was an escalation of?
There's an order, my lord, not to that there should not be any price escalation without the leave of this court, my lord. There was an order.
Where is that?
Just a moment.
That's why we remember that.
Yes. No. Dina Vitral. That is my order dated 26/9/2024. Para 10. Paragraph 10.
Thanks, Parag. Accordingly, we dispense with the personal appearance of the executive engineer from PWD NH section. What do you call NH?
National Highway Division. Nahalagan Highway Division.
Nahalagan Highway Division.
Nahalagan Highway Division.
And the contractors. We also gave an order on January to place before us the names of all the contractors and the specific work assigned to them Has an affidavit filed to that effect?
By the respondent number 7.
No. The court would require the so and so. So this is when it is contractors, I think they will have to PWD. This is the order, please check it.
Yes, yes, my lord.
27.
27/1/2025.
Just see this.
My lord, I have it here.
Okay.
But if I can intervene, Lord,
Pardon me?
if I can intervene, Lord, pursuant to your lordship's order, an affidavit has been filed where my lord has raised certain queries,
Query number.
Lord.
Yes. Where is that? Which is an affidavit? That affidavit?
Lord,
My lord, I think we have filed it. We have filed. We have filed.
Which affidavit?
Query number is that? Query number. Query number.
It's on 12th of February,
11.
2025.
Query number.
Lord, the affidavit is shown to be sworn on 12th February. Lord, I don't have the.
It has been filed, man. We have filed. Affidavit. Was
12th
sworn on-
February 2025.
No, because in the next order, Mr. Ratan,
Yeah.
which is the order dated 12/2/2025, this court had extracted the earlier order and then recorded your statement that when the matter is called up, Mr. N. Ratan, Learned Additional AG, submits that pursuant to the order dated 27 January 2025, the departmental authorities had prepared a status report and the same will be brought on record during the course of the day.
It was filed on that. It has filed. It was filed.
That is 27.
That is in the form of my lord additional affidavit. Man. Additional.
Hey, disconnect.
the respondent number 7 had more than 49% of the work to different contractors. So in this regard, the stand of the respondent numbers 1 to 6 in the affidavit in opposition, in the additional affidavit file of 19/2/2025 is that presently there are 2 subcontractors working in the stretch between Papunala to Nirjuli, namely Messrs. SPS Technocrats, TECH NOCR, Technocrats Private Limited, for 35% of the total project value, and Mrs. TK Engineering Consortium Private Limited, TK Engineering Consortium Private Limited, for 14% of the total project value for the highway work. And the breakup of value is stated to be rupees 119.35 crore for Mrs. SPS Technocrats Private Limited and rupees 47.74 crore for Mrs. TK Engineering Consortium Private Limited. Also, that we have put that query about cost escalation. Strike it out because it's already replied. As regards the issue relating to escalation, cost escalation, which was posed by an order dated 27/1/2025. In the said affidavit, it has been stated that the cost escalation, which is approved till 31/1/2024 and 31/1/2025, and that approved cost escalation is rupees 7, 82, 63, 538, and no further cost escalation is approved due to non-achievement of second milestone of 35% as per contract agreement. Mr. Ratan,
Yes, Madam.
at page 373, response to query number 8, this is this affidavit which we are now reading, which we have filed on 19/2/2025. Response to query number 8. You got it?
Response to query number
Query
8.
number 8. In serial number 1, you have said the
Yes.
contractor shall maintain the project lanes at its own cost, ensuring traffic worthiness and safety. This point, does it include that stretch from Model Village to Nirjuli?
Response to query number 8. Hello?
Serial number 1,
Yes.
same page down below.
Contractor shall maintain the project plans at its own cost.
And number 2, you say that contractor shall undertake necessary repair and maintenance of the road along with along project corridor.
Yes, my lord, here it is reflecting that as per the contract agreement, my lord, it is the contractor who has to maintain. We have stated that.
There was a person in Washington Irving's novel, Rip Van Winkle, who slept for 20 years. When he woke up, he was in a different world. Now, who in the PWD will ensure that this project lane and entire project road for the entire corridor should be maintained?
But as per instruction, my lord, to comply with this provision, to maintain the footpath, direction has been given by the department to the contractor.
Direction was given by when?
If some direction is given by the nobody. It has been continuously given, my lord, every month.
Maintenance.
Maintenance.
Then we can see you can
In March, 3rd also, 3rd of March also.
15 March.
15 also.
This last pyramid. Last pyramid, ये pyramid, last pyramid.
And after notice was issued. उसके बाद उससे पहले
Shipping है और भी है ना अभी just recent वाला भी है
इससे पहले भी
मेंटेनेंस वो तो होती रहता है मैंने लिखा है every month
Nineteen को fight
This letter is better than your affidavit.
But apparently the principal contractor thinks nothing of it.
No, that's okay, but we understand this more better. Good.
इसको बोलना है कि हम लोग को नेक्स्ट करा कैसे तो काम करेंगे उसमें
In response to query number 8 of the said order dated 27/1/2025, it has been stated in the additional affidavit that it is the obligation of the principal contractor to maintain the project lanes and to undertake necessary repair and maintenance of the road along the entire project corridor. As per clause 10.4 of the contract agreement. First of upon query of the court, on being instructed by the executive engineer present, we submitted that on 3/3/2025, instructions has been issued by the executive engineer, Naharlagun Highway Division, to the principal contractor being respondent number 7. Amongst others, to start road works directly under the contractor's supervision and through their own personal and equipment, including its maintenance as per clause 10.4 of the contract agreement. First off, it appears from the submissions of the learned counsel for the petitioner, already recorded, that there appears to be no physical progress of the maintenance work of the lanes and the road in the entire corridor. Accordingly, the next date of listing, the state PWD shall inform the court as to the
That even prior to this, several notices have been given.
pardon me.
Prior to this recent March notice.
It's okay. We are not making any. We are not critiquing it right now. Just noting what has happened. Which is followed by a reminder, by the first reminder dated 15/3/2025. Didn't say that, however, from the submissions. Professor, therefore, 800 meters from the statement made by the learned counsel for the petitioner, an impression which is gathered is to the effect that there is a failure on part of the respondent number 7 to comply with clause 10.4 of the contract agreement. And the default appears to have occurred prior to the registration of this PIM, as the said project corridor has remained unattended, 7 except making part of the road motorable due to orders passed in this PIM. Motorable for one lane traffic. For one lane traffic. Next paragraph. We leave it to the wisdom of the Public Works Department to deal with the issue relating to the repair and maintenance of the entire stretch of road, which is covered by package B. And the status of maintenance shall be informed to the court on the date of listing. Mr. Ratan,
Yes.
you can please sit down. We are not. Mr. Ratan, the ninth query of the court with regard to the traffic management. This traffic management plan has not come up. And even if it is there, it's not working. You see, traffic management plan, what we understand, is not to identify which road will take from to go from the X to Y or Y to Z. The traffic plan would also mean that deployment of police personnel, so that in the peak traffic hours, the traffic movement is there. Because in this bottleneck at the old High Court junction and this leisurely point, not leisurely, this Giants point, the traffic snarl is still there. So traffic plan is not only to say which road will be taken, but if you take a road, there must be a plan that you reach place X within a reasonable time. So it will not happen unless you have a policeman at least in few points where this traffic snarl happens. Can you take up the matter with the state police?
My
Not
lord,
with the PWD, but it will be you.
as per instruction, whenever the contractors, they propose some new construction, then they inform the department and the department has to coordinate with the police.
Okay.
That tomorrow, this is the plan, we are going to erect or we have to dig this portion. Accordingly, that coordination is been done.
In respect of the query number 9, we leave it to the wisdom of the Public Works Department to have a traffic management program chalked out by the Superintendent of Police and the Superintendent of Police within bracket traffic for managing the traffic during rush hours. We're just asking you in respect of this query number 10. This answer is at page 275. We're just asking you. You see, for example, some work is being done. Let us say erection of pillars or construction of a part of road. Whether this timely concrete test or to cut out a section of the road and to find out whether the the normal what you call layering of the earth, metal, and the topping is done up to the prescribed standard in the DPR. Whether this are being regularly done or you do it only at the end of the project.
During the course of work.
During the course also you do it.
Okay. Testing. Sampling testing. On field during the construction. ये वो ये कंपनी करता है कंपनी करता है अप्रोच इंजीनियर अप्रोच इंजीनियर एक तो दिया था ना ये एक कमीशन अप्रोच इंजीनियर उनका
Well, there is another this monitoring agency, my lord, appointed by the MORT itself. But we have there is ACOM Asian Complaint Limited, my lord. That is they are appointed by the MORT. The engineers from that
They do this testing.
yes, madam.
Okay. Okay, we leave it there.
Apart from that PWD highways.
We leave it there because this is highly technical and we hardly know anything about it. We're saying it from just from a general idea, but we don't have up-to-date knowledge on that, so we are not passing any orders right now for that. We have to train ourselves
Yes,
to
madam.
understand more and then put up orders in the next date. Next paragraph. For the next paragraph, for the time being. We are referring to only few of the issues to be considered by the state PWD amongst other issues which are raised in this PIL. Full stop. How much time we'll need to have these meetings and all and to tell us the progress?
Fine.
Maybe. Fine.
By May 5th, madam.
Huh?
May 5th, 5th of May.
May 5th. Okay. I don't know. Most of the whatever decisions that are taken by the PWD, state PWD, while doing so, they would take note of the ensuing monsoons.
Yes.
Next paragraph. List on 5/5/2025. We have exempted your personal appearance and Mr. Dubey, we have also exempted the contractor's appearance.
Madam.
But you will cooperate with the
Yes,
PWD. And based on the status, the updated status report in terms of the order shall be presented on the next date of the state.
Madam.
Mr. Ratan and Mr. Pangi, anything we have left out?
No, my lord.
This we are returning it to you.
Yes.
Because two letters you had produced. I think one I have. Thank you very much. Two letters were there. Okay.
Garbage picking through truck and this human resource is only the option. So what generally we do, if due to machinery breakdown, if one section, this sector is not the pick up, then another section, this machineries of the another sector is deployed there overtime, my lord. So generally it is invariably, my lord, two-time picking is there, my lord, in this municipal area. And one query your lordship has personally this inquired around the vicinity of this area, my lord. It is like again like shifting liabilities, my lord. But I have to be very I also have to save my clients also, my lord. This again UPI
You
is
are absolutely right.
UPI is
That
again
is the paramount duty.
my lord. UPI is again
I don't have grudge against that. I
My lord.
appreciate that, in fact.
yes. UPI is not in my jurisdiction again, my lord.
Okay.
That's why your lordship, the informer that gave the information to my lordship, might have this spoken about UPI, my lord. UPI, we don't come here at all, my lord.
Okay.
And regarding, apart from that, my lord, another backup plan, my lord, if in case,
This submission is also accepted.
my lord, if in case we fail to this, some person, some garbage is left unattended to, my lord, we keep one, this toll-free number, my lord, for citizen. They can directly call to our, give the information to our control room, my lord. That is, but that is not 7/24, of course, my lord. That is,
No, but experiencing these toll-free numbers is also exhilarating. You can have wait in the toll-free number.
my lord,
It will be from morning to evening and they won't attend. They will just say in the toll-free number,
my lord,
sir, your call is very important to us. We'll attend to you shortly.
my lord.
And then
But
you
we put our best endeavor, my lord, not to ignore any call, my lord. And
Okay,
apart from that, my lord, we are running one app, Android-based app, not of course in iPhone and Apple, my lord. We have one Android-based this Apple this app, IMC 101, my lord. That can be downloaded and it is popularly used by the citizens in the capital, my lord. Even photograph can be sent directly, and from there also internet IP-based call can also be has also been accommodated, my lord. IMC 101, my lord. That is a application we have generated and we developed and we are maintaining that, my lord. That is our backup plan, my lord.
good.
May I regarding worship, Panchayat area, garbage of the Panchayat area is collected by the concerned Panchayat segment.
By the
authority of the concerned Panchayat segment.
by the panchayat.
Whoever is the Panchayat.
But do you have a regulation to that effect?
There is no such regulation.
Because you see, there must be some duty assigned somewhere. Some duties must be assigned. If there is a panchayat, the act must say that they will take out garbage, or there must be a notification empowering this panchayat institutions to collect garbage. So what essentially we are asking is that there should be this all this must be put in place. Otherwise, it is very hard to saddle liability on a particular officer.
Because I have information that there is no such action plan.
It's okay, but if it's not there, we appreciate your honesty. But please, we are issuing a direction that they should make a plan for the collection of garbage. Because if there is no plan, then nothing works.
Otherwise, the Panchayat departments can be.
How will we make them a party? We appreciate what you say. We have made a correct statement. We don't say anything to you about that. heard Miss
Somo,
S.
Somo.
Somu, learned counsel for the petitioner. Also heard Mr. Mr. V. Jamot, learned standing counsel for the
My lord, for
the,
Itanagar Municipal
uh,
Corporation,
Itanagar Municipal Corporation.
My respondent number 2.
Respondent number 3.
My
And Ms. T. Wangwal and government advocate. Huh? Oh, I'm so sorry. I'm extremely sorry. The government advocate appearing for the state respondents. Correct?
1, 2, and 4.
1, 2, and 4. Okay.
5 also.
1, 2, 4, and 5. Okay. Next paragraph. It appears from the additional affidavit filed by respondent number 3 that the Itanagar Municipal Corporation has applied for collection of garbage only in the municipal area and the adjoining areas which are under the respective panchayats. They are not collecting garbage from those areas, and it would be the respective panchayat would be collecting the garbage within the panchayat area. Next paragraph. On a query of the court, it is submitted that insofar as the garbage dump in beyond Itanagar is concerned, the area where the garbage are lying unattended on the near to the highways is essentially the responsibility of the respective Gaon Panchayat. Next paragraph. It is further submitted that the respondent number 3 has put into place a garbage collection plan by collecting such garbage on twice a day, and they have also made available Android phone based app by which intimation can be sent to the Itanagar Municipal Corporation of a garbage lying in some public place or road. It is submitted that helpline is also activated, which works during the office hours only, through which intimation of garbage is lying at a particular place can be informed. Next paragraph. As there may be several panchayat areas within the vicinity of the Itanagar Municipal Corporation area, impleading of all the panchayats would not be feasible. Accordingly, the court is inclined. Accordingly, for the time being, the court is inclined to implead the what is the name of the panchayat institution? What do we call?
Director
No, first should be the ministry, then they will come Ministry of Panchayat, what would be the name?
Panchayati Raj, my lord.
Ministry of Panchayati Raj.
Department of Panchayati Raj, Government of
Okay,
Odisha Pradesh, my lord.
Department of Panchayati Raj, Government of Arunachal Pradesh, represented by its secretary, Itanagar Capital Complex, from Itanagar as respondent number 6. As well as the director of Panchayat Raj, represented by its director from Itanagar as respondent number 7. The registry shall take necessary steps to impede the said two respondents. Next paragraph, pending the necessary correction in the cost title for implement of said two authorities, letter notice be issued on the newly implemented respondent numbers 6 and 7. Next, Ms. P. Sagita, and government advocate, accepts notice on behalf of newly implemented respondent numbers 6 and 7. First of that, the next, the Honorable Counsel for the petitioner shall provide copy of this PL to the Honorable government advocate towards for our service to the newly implemented respondents. Next, the newly implemented respondents shall inform the court as to whether there is any act, rules or any notifications or OMs in place for streamlining the collection of garbage from the areas falling within various panchayats. Specifically adjoining the Itanagar municipal areas. Next paragraph, the learned government advocate shall send a downloaded copy of this order to the newly implemented respondent numbers 6 and 7. Bring the order to the notice of the said authority. Next paragraph, list on when. How much time?
We need some extra.
Huh. One we already ordered. She'll give it to you. We'll list it when. Yes, sir. Okay. 9th of May 2020. Sorry, not make it 9th. Make it 14th of May 2025. Please give an extra copy.
Yes.
Anything which you have left out?
No, Your Worship. Actually, I want to press the para 6, which they have filed in additional affidavit.
What was
Because
that?
page number is wrong, so I just.
No, it's okay. What was that?
It was for the installment of municipal solid waste management plant. So if they will start into 2025, they said that they will finish in 2026. So if they will file
You
a
see,
status report,
this is something which we can't compel the state immediately by orders of the court. The reason is, supposing they choose a site
yes,
which is close to your house.
yes, Your Worship.
It's just thinking aloud.
Yes,
Let us see a situation where they choose a plant site near your house. You will make objections?
yes. Actually, Your Worship, they have filed
No,
everything.
you see, we are just asking you this. Please try to understand in whichever locality they go to make this plant, there will be objections. So they will have to plan it very nicely. These things can't be forced. It will lead to a public outcry. The particular places.
Yes.
Let them take a call. They have given of their own that they will do it within 2026.
Yes.
We give them some time. But this is something which will lead to a immediate protest because of the orders of the court. We don't want to do it.
Because actually, Your Lordship, our ultimate concern is the environment, because they are
I understand,
taking.
but please understand the public sentiments. Can we force it? Can we say that there is a place at X, make a plant there? We can't do it. It is for the government to choose it, to do it in a manner which is desirable by them. Correct?
Yes.
We have seen the implications of the orders of the court when it is not appropriately passed. There will be public outcry because of that. We have to see the situation. The same thing my sister is also saying.
They choose an area, but the residents of that area, they protested before the court. So they went to NGT.
Actually, I'm saying on the basis of their agreement, which they have
understand.
already executed with the private parties.
We
So
understand.
they have already choose the
Please
location.
give them time. The location and all is very sensitive. We don't want our orders to escalate into public protests. Right? We have certain limitations. We have to be bound by that. Okay. But keep in mind, next time when she raises this issue, we'll have to respond to it. That garbage collection
Plant.
site, that plant.
Sewage plant. Plant.
Plant, that is, our proposal is one Guwahati-based organization.
No. Have you selected this site? Have you identified the place? Is there a site identified?
Yes, actually, it has already been earmarked to us, for us, my lord, by the government, my lord. Actually, that was a landfill area, government identified for us, earmarked for us, my lord. On that, we are developing municipal waste management plant, my lord, where this municipal waste will be converted to charcoal, my lord, for household use and all that. There is some technology on the basis of which we are trying to expedite it, my lord.
Okay, just on the issue raised by the learned counsel for the petitioner, Mr. The learned standing counsel for the Eternal Municipal Corporation has submitted that they already have a earmarked landfill site to be developed into a waste management plant. So it is submitted that certain issues for which there is time bound, for which they need some time to effectively start the plant.
Yes, ma'am.
For which the timeline has been mentioned in their affidavit filed on behalf of respondent 3. So please take note of that submissions. The said issue will be taken up in the next date. Other matters, I think will not take up. Was a single bench. Which items? Inside hearing matters. Not be able to take up right now.
Pilot in item 7, petitioner, they were about to mention it, pilot, petitioner's counsel is not there. But however, in the earlier order, pleadings were treated to be complete. I have checked the records, the Pollution Control Board, they have not filed.
Pollution Control Board is respondent number.
3. Respondent number 3. Pollution Control Board.
They have not entered the appearance. The notices have, but they did not enter the appearance.
Yes. In fact, I have been informed that they will be filing, they have received, they will be filing.
But we don't know till. We are not saying anything.
Yes, my lord. Another date may be given, madam.
No, because if you have to write an order, then we'll have to say that the additional application will enter the appearance and then pays for time.
No, my lord, just, then in that case, just a simple date may be fixed, my lord. We'll inform you.
John, due to positive time, that could not be taken up today. List in the week commencing 5/5/2025 on a date to be fixed by the registry.
Early. Thank you.
23rd. You want to say anything?
23rd
of April by.
23rd is immediately after the opening. It's very difficult.
I know the pleadings are complete except that.
But all these matters are being adjourned. In all these days, we have been adjourning matters after vacation. The ratio will not be able to.
My lord, in fact, there is an urgency by the private respondent.
No,
Because
but
of the
we have to
pendency of
take
this.
care of the ratio, because you see, we may fix it, but there are so many matters being adjourned. Last 2 weeks, we are only adjourning matters after vacation. It leads to a very difficult situation.
I 15th May, madam.
On 5th.
5th May. So why is the urgency there in your on your account?
My lord, we are getting affected. My lord, there's a connected writ petition also.
Yes.
My lord, due to the order of the Geology and Mining Department, my crusher unit has been stopped for the last 7 to 8 months. And this being the working season. There's a connected writ petition, my lord. That is why it has been connected with this PIL. Because in the writ petition, I was pressing for the.
But the matter is pending for the NGT. What has happened there in NGT?
My
What is
lord,
the present status of proceedings in NGT?
My outcome of the PIL will outcome of this PIL will help my writ petition.
You have a different writ petition.
My lord, I'm a party in the PIL as private.
That's what we are saying. You see, you have what you call the order in that NGT was challenged by you. Is it right?
My lord, what happened?
No, we understand. You see, so far as in this writ petition, this PIL is concerned, you will be just a proxy. What you call in proxy, you will be dealing with the other writ petition.
But what happened?
I just remember that this NGT, in this case, the NGT passed an order. That order has been challenged.
No, my lord.
No. There's no.
There is a case pending against the private respondent before the NGT by some other petitioner, and here by some other petitioner.
What is the proceedings of National Green Tribunal OA number 10 of 2024 East Zone?
My lord, my lord, I have to take instruction, man. But anyways, my lord, same course of action.
NGT means by some other party. By some other party. In fact, my lord, in case of this like.
See this order.
Only for one of the parties. Only one of them. Main tribunal. Status.
There must be something when there is an order of the court. If it's not there, you have to tell us, because that's the issue. If it touches the orders of the NGT, then we must be aware where how we are dealing with it.
My lord, same course of action.
Cause of action is something else, and whether it's a proxy litigation against in respect of the order passed by the Green Tribunal, that is the specific query we are having. Once we exercise jurisdiction in this PIL, will it be
My lord, I have a judgment to that effect. Where the same course of action is lying in the High Court or in the NGT.
You see, you understand the implication. In a PIL, whether any order passed would have material bearing on the orders passed by the NGT, which is over which we are not in session. In this PIL, the orders of the NGT is not a subject matter. Therefore, the query is whether any order passed would have a bearing or a ripple effect on the matter which is now pending before the NGT. There's two ways of putting the same question.
Understood, my lord.
Correct.
My lord, PIL was first filed, and then another petitioner filed the same thing in the.
We have get the order of the NGT.
We find out because
Tell the court that.
exactly, exactly.
Contradictory with the either party of the NGT.
The same issue.
All sides are represented. All sides except respondent number 3 are represented. The parties are put to notice about the order dated 10/3/2025, by which this court had directed the learned counsel for the petitioner, as well as to the learned additional advocate general for the state, to inform the court about the status of original application number 10/2024/EZ, which is pending before the National Green Tribunal, Kolkata. Accordingly, the matter stands adjourned to enable the said information to be apprised to the court. List on 5/5/25. Subject to availability of the bench.
Malad, may I mention item number 9?
We are adjourning those matters.
Malad, we wanted to have on specific date as consented by the other party, 29th of April.
29th.
Of April month, this month. Item number 9.
Can you have any other day after that? Because
Malad.
we are adjourning all these matters after vacation. We don't really know how to deal with it.
Malad.
Can it come to May, any day in May?
Yes, ma'am. 6 May, Malad.
6, okay. That's positive matter to be taken up today. List on 6/5/2025.
Malad.
Subject to availability of bench.
Development.
Or any other matter left on same order. Yes.
May it pleases your lordship, I would like to mention a motion matter, lordship. If it's allowed, then I may move it today. I have filed today morning only, lordship.
What is the matter about?
This is about the jurisdiction of Human Rights Commission, lordship. exercising the function without jurisdiction, Lordship, which is assigned under section 21(5) of the Human Rights Act, Lordship.
Okay.
Lordship, on behalf of Senior Government Advocate S. Tapin, I would like to mention item number 9, 10, 11, 40, and 51.
9,
10,
10,
11,
11,
40, and 51.
14, and
51. He's not well, Your Lordship, so Lordship, these matters may be taken up after Bihu break, Your Lordship.
you have taken consent.
Yes, Your Lordship, I've taken the consent of all the petitioners.
Okay, but if 14 goes, then 13 also goes. 13 is connected.
40, Your Lordship, 40.
So not 14.
Not 14, Your Lordship, 40.
9, 10, 11,
Yes,
40 and 41.
yes, 40 and 51, 51.
15, 15.
Obliged.
Who is indisposed, you said?
Lordship,
Who is indisposed?
he's the S. Tapin, Your Lordship, Senior Government Advocate.
Okay.
Okay.
Separate orders. On the ground that Mr. S. Tapin, Senior Government Advocate, is unwell. Yes. R. Basad, Honorable Government Advocate, pays for adjournment. Here is allowed. List.
The Bihu break, Your Lordship.
Just after next week, give vacation on a date to be fixed by the registry.
Obliged.
Please make mentions if dates are not immediately fixed.
Lordship, I would like to mention item number 8 on the behalf of Mukherjee sir. Lordship, here we have to file the reply in affidavit. For that, we need some more time. Item number 8.
But this is an old matter.
So forest.
In the earlier order, you said both sides are represented. Here also same, both sides are represented.
Item number 8. 8.
The Learned Counsel for the petitioner. Pays for some more time to file the joint affidavit. So prayer is allowed. The joint affidavit shall be filed at least shall be filed within 2 weeks positively. This is the matter after issuing new vacation or command a date to be fixed by the registry. 2 weeks time we given to file.
May I, Your Lordship? Item number 7, Your Lordship.
Item 70.
7, Your
7.
With the consent of the other side, Your Lordship, may it be fixed on 23rd of this month, Your Lordship.
23rd is immediately after vacation. It's very inconvenient. We'll make it next week. We'll take it on. Have it on 30/30.
30, Your Lordship.
The immediate opening week I want to avoid.
Yes, Your Lordship.
Item 7. Both sides are represented on the prayer made by the government advocate. Madison is adjourned today. List on 30. 4/2025.
Obliged, Your Lordship.
Yes.
May I please, my Lordship? I would like to mention item number 34. Your
34.
Yes, sir. Yes, my Lord. 34. Your Lordship, standing counsel for the respondent number 2 and 3.
Your item you are playing is 34. Which item?
Item number 34, Your Lordship.
34 is a connected matter. We can't adjourn one matter. You have to wait. These are connected with series. You'll have to wait.
May I please, Your Lordship?
Your Lordship, I beg to mention item number 44, Your Lordship. This matter may be closed, Your Lordship. The prisoner want to praise this matter, Your Lordship. This matter pertains to non-payment of salary. However, during the pendency of this writ petition, the department has paid the salaries to the petitioner. So this matter may be closed. Okay. Mr. Ibam, Your Lordship. My name is not there in the Mr. Ibam. Both sides are represented. Mr. Ibam, learned counsel, appearing on behalf of Mr. Arthur, learned counsel for the petitioner, submits that he has received instructions from the petitioner that during the pendency of this petition, his grievances have been redressed. Accordingly, on the grievances being redressed, this petition stands closed on the prayer made by learned counsel for the petitioner. Any interim order is operating? No, Your Lordship. Okay.
May I please, Your Lordship? Your Lordship, I beg to mention item number 6 on behalf of Mr. Estapin, Your Lordship. Your Lordship, he had some health issue, Your Lordship. Therefore, Your Lordship, kindly adjourn this matter and fix after puja break.
Inform Mr. Thakur.
Yes, Your Lordship.
Okay.
Yes, we have taken the consent.
Both sides are represented on the prayer made by the government advocate. The matter is adjourned today. They start raising due vacation on a date to be fixed by the registry.
Obliged.
Any interim order is there?
Yes.
Okay. Interim order passed and is extended till the next registry.
Now I can mention item number 52.
Item
52.
50?
52, Your Honor. On behalf of T. Tagum, Standing Counsel for Education Department, Your Honor. And he's having some health issues, therefore he couldn't appear. Therefore, Your Honor, this matter will be adjourned.
Both sides are represented on the prayer made by learned counsel for the petitioner. The matter stands adjourned today. We are praying for the petitioner.
I'm for the respondent. Your Honor.
For respondent.
I am for the petitioner.
Okay.
52. No?
Yes.
Let it be fixed on 30th of April.
Okay. You are respondent number?
All respondent.
All the respondents. Okay. The matter stands adjourned today. List on 30/4/2025. Okay.
May my lord. I would like to mention item number 47. Here I am for the private respondent number 4. My lord. Recently, we have filed our wakalat now. We need some time to file our affidavit in opposition.
You will inform the other side.
Yes, my lord. We have taken the consent.
Both sides are represented. On the prayer made by Mr. B. Pisat and counsel for the private respondent, the matter stands adjourned to enable him to file affidavit in opposition to the matter. Just after 2 weeks on a date to be fixed by the registry.
My lord. Obliged.
May I please, Your Lordship? Your Lordship, I'd like to mention item number 41, Your Lordship. Here in this case, Your Lordship, I am for the private respondent number 6, Your Lordship. And I have filed my counter affidavit today, Your Lordship.
Okay. We have informed.
Yes, Your Lordship, I've taken consent from the petitioner as well as from the government.
Okay. Both sides are represented. Mr.
E. Menjo, Your Lordship.
Pardon me?
No, Your Lordship. E. Menjo.
E. Menjo, the
Yes.
counsel for the private respondent, submits that the affidavit in opposition has been filed today, which is not on record. So let this affidavit be brought on record. Matter stands adjourned today. This after receiving the vacation on a date to be fixed by the registry.
Highly obliged.
My Lordship, with the consent from other side, Lordship, I beg to mention item number 42, Lordship. Leading counsel, Mr. Titi Tara is out of station, Lordship.
42.
42, Lordship.
Okay. Both sides are represented on the prayer made by Learned counsel with the petitioner. Matter since adjourned today, this doctor. Received the vacation on date to be fixed by the registry. Okay.
Lordship, there is an interim order also.
Okay, interim order passed to this, extended to the next date of this.
Lordship, I'm board respondent number 6. Fixed date may be given.
You want a fixed date?
Yes, Lordship. 10th of May.
10th of May.
Yes, Lordship.
10th, we can't give you that date. It is reserved for a holiday.
Nine may be fine.
9th, okay. 9th, okay.
Obliged.
Yeah, Lordship, I'm extremely sorry, Lordship. There was an interim order in item number 44. Lordship. I'm extremely sorry, Lordship.
44.
Yes, Lordship.
Might please, Your Lordship. Lordship, this is transfer matter, Lordship. Now I would like to withdraw this matter, Lordship. This matter has become in process, Lordship.
Upon instructions. Mr.
B. Lona.
P.
B. Lona.
B. Lona, learned counsel for the petitioner. Submits that during the matter has become infructuous, and therefore here's instructions to withdraw the petition. You want to withdraw it, or it's closed as infructuous?
Infructuous.
Okay. Become infructuous. Next paragraph, Mr. Y. Renowned only government advocate is present. Next paragraph. Matter is closed, having been rendered infructuous. Okay. Interim order passed on 6/3/2025 stands vacated.
Last.
May it please, Your Lordship. So this tender matter, my lord. The name of the work, my lord, is construction of road from L031 to Neo-Korean to Lenerian, my lord. My lord, the last date for submission of bids was 23rd of March, and date of bid opening, my lord, of technical bid, my lord, was 24th of March. My lord, I had submitted my bid, and there were total 6 firms who had submitted their bids, my lord. I was found to be non-responsive, and 2 firms have been recommended. My lord, the technical bid evaluation report, my lord, is from page 30.
But they have assigned reasons. They did not spell it out, but they say that the clauses referred.
My lord.
SBT section 2, IBT clause 4.2.
My lord.
This they have raised a few clauses.
My lord, they have simply mentioned those clauses. But my lord, I have submitted those. My lord, clause 4.2.1, my lord, is in Lordship may find it at page 46. 46, my lord.
Yes.
My lord, towards the middle of 4.2. 4.2a starts at page 45. Yes. Was the middle, my lord.
Yes.
It's 5 years in which the bidder is involved, parties concerned, the disputed amount matter.
Yes.
Now, why not may come to page 74, my lord. This is in section 3, what is required. Section 3 starts at page 71.
Yes.
Qualification information. Then 74 corresponds to 4.2A1. information on current litigation in which the bidder is involved. They've given a table. My lord, an additional affidavit has been filed today. My lord, I'm sorry, my lord, it was not annexed with the writ petition. An additional affidavit has been filed. It's on record, my lord.
Yes.
My lord, I had submitted this along with an affidavit at page 388, annexure 15 series, my lord, of the additional affidavit filed today, my lord. Page 388, my lord. That is the affidavit.
Okay.
And page 389 is the form. Form which lordship has seen in page 74. This is there. Similarly, my lord, as respect of the others, my lord, clause 4.7.
What was the last date of submission of bid?
Last date 23rd of March 2025, my lord. 20. Oh,
Okay.
25.
Yes.
And date of bid, technical bid opening, 24th of March. This technical bid evaluation report is for 1st of April, my lord, 2025.
Yes.
Then, my lord, clause 4.72. That is the second ground which they second clause which they have referred to. Lordship will find this at page 50. 50, my lord.
Yes.
My lord, 4.7 to clause 4.7 starts with even though the bidders meet the above. Lordship finds that even though the bidders meet the above qualifying criteria, they are subjected to be disqualified if they have two.
Yes.
My lord, record of poor performance such as abandoning the works, not properly completing the contract, inordinate delays in completion, litigation history, or financial failures, etc. My lord, this is their part which they have to provide. I do not have any poor performance record, my lord. I have submitted my bid capacity. There is no litigation, no past litigation whatsoever. This is the justification has to be given by them. It is not there in the record. It's just an omnibus statement. But what is the misleading or false representation, my lord, or poor performance? That they have not specified. Thereafter, my lord, is section 3, qualification information, 71 to 74. Page 71 to page 74.
Next.
My lord, page 71 to 74 is the qualification information in section 3. Section 3 is the third clause which they have referred to. Now, from section 71, my lord, the formats they have given, clause 1, my lord, we have complied with everything, my lord. Clause 1 starts from page 131 of our submitted bids. If lordship takes both the pages side by side, my lord, page 71 vis-a-vis 131. Whatever they have required, we have submitted. Then next is clause 1.2. It's also there in page 31. 1.3.1 from page 132 to 157. One 132 to 157. We have given the details. The previous works performed as prime contract.
Page 137.
Till 157.
137 to 150.
132 to 157.
132 to
157. 132 and 133 are the tables, my lord, in which the required details are there. And thereafter, the supporting documents from 134 to 157. Okay. Then, my lord, may come once again turn back to page 71, my lord. These are the subcontractor details project. This is clause 1.3.2. They have written 13.2. This lordship will find at page 158. We have not performed any work as subcontractor. One 158. No work as subcontractor. Then, my lord, page 13.3, my lord, at page 72, information on bid capacity, works for which bid have been submitted and works which are yet to be completed as on this date. Page 159, if lordship refers to.
One 139.
159, my lord.
59. Yes.
The bid capacity is worked out, my lord.
Yes.
Now, if lordship again turns back to page 72, my lord.
Yes.
The next component, existing commitments and ongoing construction works in bold. Now, lordship will find this at page 160.
160.
160, my lord.
Yes.
And if the details are there, my lord, in the tabular form as required. Then from page 1, since lordship is at page 160, my lord, from page 161 to 165 are the engineer certificates. This is required at page 72. From 161 to 165 are the engineer certificates. This lordship will find the requirement at page 72.
72.
72, just below the table which lordship has just now there, in the asterisk, my lord. Then
Yes.
now, if lordship if lordship is on page 72 itself, my lord, just below that is the availability of major items. The
Yes.
details we have given from page 166, my lord, to 313. All details are there, my lord. All the equipments with corresponding documents, my lord. And my lord, at page 72 again, qualifications of technical personnel proposed for the contract. This is from page 314 to 339, along with their certificates. Up to 339. 314 to 33.
Okay. Yes.
Then, my lord, at page 73, the next requirement, proposed subcontractor. We do not have any proposed subcontractor. At page 340, we have given the requirement as per the table. 340.
Yes.
Now, again, if lordship turns to page 73, my lord, financial reports for the last 5 years. This requirement we have met, my lord, from page 341 to 368. Yes. Thereafter, my lord, name and address, telephone number, FASMISAL number of banks that may provide references if contracted by the employer. This we have given at page 369. Yes. And thereafter, the last one, information on current litigation in the additional affidavit which Lordship has just some time back read, my lord. So all the requirements are met of clause 3. Yes. So therefore, my lord, the rejection on any of these grounds, and thereafter, my lord, there is another clause mentioned, 4.4BA2, affidavit that the information furnished in the bid documents is correct in all respects. This Lordship will find at page 48 and our document at page 370. Affidavit on correctness of bid. Page number? Page 370, my lord. Yes. This is there. So therefore, my lord, their contentions in the technical evaluation report for rejection of my bid, my lord, are negated by the documents themselves. Therefore, I could not have been rejected. And my lord, interestingly, with the very same documents, they have found us to be responsive in another bid out of the same package, not the same package, my lord, of the same LIP.
If page 370 is filed here in the red petition, how could you submit the same document in the bid also?
No, my lord, this is a photocopy of the document which was submitted, my lord. This is photocopy. 20th, dated 20th of 03. It should have been March, my lord, if Lordship sees the date. 20th of March 2025. The date of the affidavit. This is a photocopy. All these were uploaded, my lord.
This is not a photocopy, this is the original.
This is uploaded, my lord. Uploaded in the site. It's a e-tender. So we have
Uploaded in the e-tender. Okay.
Right. Now, on the basis of the very same documents.
Tarak, in your website, when you accept documents,
Yes.
is every document given a hashtag?
Yeah, it will be there.
No. Whether the documents are there or not, that's not the query. We're saying that if documents are uploaded in your system, whether this document generate hashtag is generated for each document or not.
That I have no idea.
We'll explain it to you.
My lord, otherwise this case.
No, we'll explain it to you. You see what's happened. What happens is that, let us say that, say for example, this is the document you are uploading. You want to send some document somewhere, and this is the document you are uploading. It comes to me. I say that no, you have not uploaded this document, but you have uploaded some other document. I say that you have uploaded this book. This page you have uploaded. Correct. You say that you have sent this document. I say that I have received this document. This can only be avoided if the documents are given a unique hashtag.
That is not sure. Whatever is uploaded, it should be there.
No, Lordship's okay. Lordship's okay. Is whenever the documents are
It doesn't happen. Okay, yes, what do you say then?
But otherwise, the ground on which is 37, he has filed one affidavit, correctness of his documents. Now he is talking about the non-litigation, the affidavit. In the column itself, he has written nil. There was no litigation during 5 years. Even for same project, the vibrant village, still recently, there was several litigation by this petitioner in the same division. So here, suppressed that fact also. That itself is a ground for rejection of his bid. There was litigation.
Okay.
So he has published that litigation nil. So on that ground, it was rejected.
You have a document?
My lord, let it be take after day after tomorrow. I'll bring all the case which he have filed. Petitioner filed.
Okay, if my lord sees, oh, sorry. If my lord sees the requirement at page 74, this is information on current litigation in which the bidder is involved, not past litigation.
Whatever way, but once Mr. Tarak is saying, let him produce it, then only we can appreciate what is the document you have.
My lord, there were some writ petitions filed in this honorable court.
4.2I, information regarding any litigation arbitration during last 5 years, in which either is involved, party concerned, disputed amount in matter. That is also there. So this ground also you are.
So we will take it up day after tomorrow, you produce that.
There is another aspect, if Lordship permits. The recommended bidders who are respondents number 6 and 7 here, in respect of their documents, I have submitted representations, but it has not been considered. If my lord comes to some of their documents, respondent number 7.
What is the procedure prescribed for objecting? In a e-tender, what is the procedure prescribed for objecting?
Within 5 days after opening of the technical, after publishing it, within 5 working days, they have to submit representation, which will be put for resolution.
Well, it was the technical bid report is of 1st of April. We have submitted the representation on 3rd of April.
Where is that?
Page 120 to 128. Annexure 4, page 120.
You said that the technical bid opening was on 24th.
Was uploaded on
1/4.
2025.
In the first paragraph, my lord.
Which page?
Page 120. In our representation.
No, when you were making your submissions, then you said that the technical bid, the last date of submitting of bid was 23/3 and the technical bid opening was 24/3.
24/3. 24/3.
But the results were uploaded on
1st of April.
Okay. Okay, on that day, please get information of that also. Of the objection raised. It contains the eligibility of Skenge Constructions allegedly submitting a fake invoice.
Well, in 2016, one document is there, my lord, when they have applied GST. The GST Act came on 1st of July 2017. My lord, at page 375, my lord. And before that, page 371 onwards, this is of documents of the respondent number 7, 374. If lordship sees dispatch advice, sorry, my lord. Sorry, my lord, starts at 371, my lord. I'm sorry, my lord. 371. Plus the top, my lord, just below tax invoice, lordship will see dated 7/4/2017. And below to Kenge Construction, Itanagar, Papumpare, lordship will see your order number so-and-so dated 4/4/2019. The tax invoice predates the order by 2 years. This is repeated, my lord, page 372, 373, 74, and page 375. Interestingly, my lord, these are similar ones up to 374. 375, lordship sees the date of the invoice 16/12/2016. And lordship will come just below towards the middle of the page, above grand total, GST 18%. In 2016, there was no GST, my lord. So only on 1st of July 2017, the GST Act came into force. After economy. Okay. Then, my lord, they have at next page, my lord, 376. They've submitted a bar chart. The act is there, my lord, 1st of July 2017. And the act is of 2017. Yes. Then, my lord, the bar chart which they're relying on, page 376, lordship will see the name of the work just below the bold bar chart, name of the work. Construction of L022 road from Palo to Machane, PMGSY road. This is not the work, my lord. The work, my lord, is construction of road from L031, Neo-Korean to Lenerian. But he is recommended. In respect of R6, my lord, the list of key equipments, the documentary evidence is required, as lordship has already read the note in page 67. They have not uploaded any list, any documentary evidence in respect of ownership of the key equipment, like we have submitted, my lord. This is in respect of our respondent number 6, my lord, TG Construction. So there was another point taken in the representation about, my lord, but that in my humble submission was incorrect, my lord. This particular respondent number 6, my lord, is not a joint venture. So therefore, that trading license which was referred to, my lord, I will not be submitting on that, my lord, because that in all likelihood was incorrect, my lord. This is only as TG Construction, not as a joint venture. But which one? My lord, they have taken a ground in the representation that the trading license of one of the partners of a joint venture with TG Construction, Lukam, Yasi Carriage and Construction Associates, have expired. But the petitioner was under the impression, my lord, that it is the same joint venture which has been recommended here. But this is not the joint venture, my lord. This is only TG Construction. So therefore, I'm not making the submission on that, though it was there in the representation. So, my lord, in respect of respondent number 7, my lord, fake documents apparent on the face of the record, but they have recommended. Respondent number 6, my lord, they do not upload the documentary evidence in respect of ownership or, my lord, that they have the equipments available with them, but still they are recommended. And I have been found to be non-responsive, my lord, though we have submitted all the documents. It's apparent, my lord. Okay. But there was a similar, in a similar repetition, my lord, an interim order of protection was granted, my lord. We are taking it up day after tomorrow. Produce it on the day. So then, tender matters, you're not. Interfering at this stage. Next.
And Mr. P.D. Nair on the counsel for the petitioner. So he has, next one, he has submitted that the petitioner had participated in the tender in question. However, during technical evaluation, the bid of the petitioner was rejected as non-responsive on the following grounds. Give a dash and then inverted commas, SBD, comma, section numerical 2, comma, make it next line. Make it semicolon instead of comma, semicolon, ITB, clause 4.2 within brackets, small I, bracket closed, semicolon, clause ITB, comma, clause 4.7 within bracket, small Roman 2, again semicolon, section 3, comma, qualification information, semicolon, SBD, comma, section 2, numerical 2, semicolon, and ITB, clause 4.4, capital B, within bracket, small a, within bracket, small Roman 2. Next, it is by referring to the documents next to this requisition, it is submitted that the petitioner has disclosed all the information and documents, and therefore, on those clauses, the petitioner could not have been held to be non-responsive. Next, it is submitted that insofar as the bid of respondent number 6 is concerned, is 6 or 7?
7.
7 is concerned. The nature of defects are stated in the petitioner's representation dated 3/4/2025. And by the full stop. Moreover, by referring to the documents uploaded by the respondent number 7, along with his tender, it is submitted that those documents, that some of the documents which have been annexed in this petition in respect of respondent number 7 are either manufactured or fake. Which can be easily exposed from the document itself. Next, accordingly, it is submitted that the rejection of the tender of the petition is not sustainable on the grounds disclosed for rejection. Next, it is also submitted that in a similar, in respect of a similar tender, this court was pleased to grant an interim order. Next, Mr. G. Tarak Lanet, standing counsel for the Rural Development Department, submitted that he has received instructions to the effect that the petitioner had stated in the he had stated while submitting the bid that he has no litigation history. So our comment has submitted that the petitioner has a litigation history which is suppressed. He pays for 2 days time to obtain instructions and to demonstrate that before the court. Next problem. So when I have said that they submitted fake documents, it's not submitted. When that paragraph ends, you say it is also submitted that the respondent number 7 had submitted a bar chart of estimated time for completion of the work. So, however, comma, the said bar chart submitted by the respondent 7 does not relate to the work for which the tender in question was issued. Accordingly, comment on the prayer made by London standing also for the RWD is granted time to produce the documents to show that the documents that the petitioner has not disclosed all material facts. It would be appropriate to direct these concerned authorities of the rural department, rural development department, produce the copy of the tender submit the tender of the bid submitted by the petitioner along with all the documents annexed thereto. Next list on 10/4/2025.
My lord, if they award the work in the meantime, my lord. But that is my anxiety, my lord. Till then, my lord.
No, that if any work order is issued in the Impleadment, the same will be subject to any further orders that we passed on on the next date of listing.
My lord.
Let's say list on 10/4/2025.
Deeply obliged. My lord, the interim frame may be considered on the next day. There, my. It was another submission in respect of R6, my lord.
We have not even we're not gone into the merit. We just
My lord, could I be permitted to appear virtually day after tomorrow?
Yes.
My lord.
From the
My lord, my lord. Deeply obliged.
Just add the last concept of the petitioner. Please for permitting to appear on the next date through video conferencing. So there is a
My lord,
yes, yes.
Well, the factual aspects has already been described by Lordship in WPC number 141 at page 16, my lord, paragraph 2. But I have extracted that entire the factual aspects. My lord, on the basis of this, the specific direction is at page paragraph 11, my lord. May I read paragraph 11, my lord? The factual matrix is not disputed. This is
Mr. Patin.
Yes, my lord.
where is the decree?
My lord,
Where is the decree passed in this case? Where is a copy of the decree which is passed in this case, which
my
is
lord,
sent for execution?
that I have not annexed because
You
this
see,
that has been already.
I personally have reservations of issuing any directions in a writ petition for execution. The reason is that then the requirement of law, which is Order 21 Rule 11, to file an application for execution and then sending it. That's number one. Second is that the satisfaction of a decree must be recorded by the executing court. And I have not been able to understand, if there is a civil decree, why would it go to the deputy commissioner for execution?
My lord, the direction by we have filed the execution petition. The court that directed
We
that.
understand, but that's highly irregular. Civil decree must be executed in the manner which is prescribed. Therefore, I have expressed my reservations. Notwithstanding that in the earlier round of court, this was issued, but perhaps the court was not apprised
My lord.
Of the relevant provisions. You see, this, under the CPC, Mr. Patil, Order 21,
My lord, yes.
11 is the provision for filing of the application.
We had filed
Then-
that, and then unfortunately that because the time there wasn't any code in Tapurijo, so directed the deputy commissioner to carry out the order.
You see, the court will never be vacant. There will be somebody who's been made in charge. Supposing this is something which do administratively daily. I am the portfolio judge for a particular district. And if there's a officer which is who is taken leave, then we always make it a point to make somebody in charge. 24 and 25, that is the
Yes.
provision, record satisfaction. Now this, always we appoint somebody in charge. The second is that in a charge post, there are two classes of charge post, one for the district judge, one is the CGM or charge post. Invariably, charges are handed over, and insofar as the civil courts are concerned, we always the in charge court is always made because they will not pass any orders, but if urgent matters are there, they will pass some orders if required.
Otherwise, my lord, since this order was given and the deputy commissioner, rightly or wrongly, they had a meeting and then he had come to a specific decision at serial number 3. This itself, he could not have done this. So, my lord, in the meantime, my lord, as your lordship is,
Look at 25. Look at 25.
yes, my lord.
Look at 25. You can technically do it.
My lord,
Let's see
that's what, my lord. May I just, as on today, my lord, the most probably the civil code is available in the Tapurijo. May I just pray that let the notice be issued, and in the meantime, I will.
Notice will not be issued because that's the whole difficulty. In an execution case, it must be registered in a manner which is provided in law. That's why we are showing it to you. You see, where is the execution application? Then 25, you see the manner in which the decree was executed, and if not executed, he will have to say that.
Well, that's what the deputy commissioner, the executing court had directed the deputy
I have
commissioner
difficulty in accepting it. You see, come to this order, which has been passed by the deputy commissioner. This order at page 32 is not in accordance with Order 21, Rule 25. You see, just few days back, there's a judgment of Supreme Court. I'll tell you, I won't be able to because it may not have been uploaded. It came about 4 or 5 days back. What has happened? Let's see.
Malad, here in this case, the executing office, enforcing office, are to execute the decree, and the decree is for the in its entirety the legal land. This is
Can you tell us what is the date of judgment?
It's given in paragraph 2, Malad.
Just tell us.
27/12.
15/7/22.
27/12/2007.
Now, you know the first error which has crept in this judgment. An execution petition which is filed after 2 years, notice is mandatorily required to be given.
Well, that was given, all process was carried out
But
in
this order was directly issued to the.
Well, because here this order was passed because the deputy commissioner did not enforce the order as required.
Then it is for the civil court to write to the high court to drop a contempt. But
Therefore, a contempt petition is also pending.
But you come to page, please come to page 16. Please come to page 16. Who is the judgment debtor from here? What do we get it? Who is the judgment debtor here?
27/12. May I read the entire paragraph, Malad?
No, page 16/16 of this writ petition. The names of the parties are here. Out of these 6 respondents, who was the judgment debtor?
Malad, since the direction was to the deputy commissioner and the additional deputy commissioner, so I have made them the party. They were to enforce the decision, and they could not have come to any conclusion, Malad. In its order in the minutes at page 31, Malad, they have come to a definite findings that.
You see, number 1, from page 32, the judgment which is in put to execution is a judgment of 27/12/2007.
Yes, Malad, this is at page 16, 17.
Right. A judgment of 2007 is barred by limitation under Article 136 on in 12 years. This order would be not binding on us. This page 141. An execution was issued by an order passed on 15/7/22 after 12 years of limitation being expired. The limitation expires in 12 years. Where is the Limitation Act? 136 or 137, I forgot. It will be a gross nullity.
Malad, this execution petition was in the year 2013.
That's why many issues are there. Now there's another point. If the execution petition is not pending, then High Court will have no jurisdiction to issue any writ. This is first. Number two, please refer to the judgment, 5-judge bench, constitution bench judgment of Mirajkar. You've seen that Mirajkar judgment. Supreme Court has barred that a writ cannot be issued on a court.
Now, in that case, my lord, I cannot go back to the executing court. Executing court has already passed an order.
That execution itself, once there is a closure report given, it's time part you could do nothing. Naresh Sridhar Mirajkar. You please see this judgment, 1967, year 1967, Supreme Court 1. Oh, this is a 9-judge bench. And all of them, all of the lordships as they were then, are all stalwarts. P.B. Gajendra Gadkar, A.K. Sarkar, K.N. Vanchu, M. Hidayatullah, J.C. Shah, G.R. Mudholkar, S.M. Sikri, R.S. Bechawat, V. Ramaswamy. It's a unique bench of 9 judges. Mirajkar prohibits issuance of writ of certiorari under Article 226.
This education petition filed in 2013 was disposed of on 14/7/2014.
That's precisely I was coming to. If the execution case of 2007 is closed in 2014, can it be revived? Answer would be no. It can't be revived.
Now, my lord, in that case, since the enforcing authority.
Because you have a paper degree now. You have a paper degree. You just have it and hang it. Yes, 136. I'll show it to you.
Well, the question of equity and then.
No equity, justice, and good conscience. Bad by limitation means bad by limitation. And Mr.
No, my
Patel,
lord, my lord.
in a lighter note, I will tell you, I was ill. I went to a doctor. He checked me up and said that, sir, you don't have a heart.
My lord, the judgment was in 2007. Decree was filed in 2013. Order passed on 14/7/2014. So that is within, to my respectful submission, that is within 12 years of time.
But
Now,
now
my lord,
when
the question is, the enforcing authority.
Once 12 years is passed, you'll have to show that the execution case is live. The only legal requirement to pass any orders by any court.
In that case, even the enforcement also will include within this period.
No, not enforcement. It must be live. You file an execution case for some reason or the other, it keeps on dragging for more than 12 years. It will be live. A petition filed within limitation doesn't get expired. But your case is that the satisfaction is recorded to be closed. So then now when we touch this matter, it will be barred by limitation under Article 136.
But this execution petition,
I was
14, today is 15. So
I was referring you to that judgment of Supreme Court of India. I just forgot the context. It is in context of a judgment passed by the Calcutta High Court that went to the Supreme Court. What happened was that in an execution case, the executing court passed some orders. After that, the High Court, a series of litigations went on with that execution, and the executing court passed an order to issue ex parte execution against the decree judgment debtor. And this is very well written judgment. The Supreme Court poses a question. When the execution petition was pending for so many years, why we ask ourselves why the court did not deem it necessary to issue a notice on the respondent before execution took place. That's why with that piece of judgment I have read, here in this order at page 16, number one, in this petition, it's not clear who is the judgment debtor. Second is that in the earlier round of this writ petition, WPC 141, an order was passed. I can't understand who is the judgment debtor. Therefore, this will be a judgment which is sub silentio. It doesn't create a precedent. When orders of execution was passed after a period of limitation without dealing with that, and without mentioning as to who's the judgment debtor. Thirdly, when the court has not recorded its satisfaction that the execution petition was pending. And fourthly, when the court did not ascertain that the execution petition was properly filed before the executing court and executed in accordance with law, the direction of the High Court to the Deputy Commissioner to execute it.
No, my lord, it is the admitted fact that the execution petition is not live because execution petition was disposed of in 2017. Then the executing court has directed the Deputy Commissioner to enforce it. So he is the enforcing authority. Now, since the enforcing authority has not enforced as per the decree, so
because you see, when you come to the exemption, the form in the CPC, you'll find something interesting. Rule 11 in the form.
so this cannot be just made to be a paper execution because if this 12 years is also
certain things we don't have an answer. Oh, no. Civil corporation orders. Civil
your
corporation.
lordship can give a insight as to what to do because substantial justice has also to be
No,
done.
not in execution because this is substantial justice is something which is covered by Article 142. Unfortunately, I'm not vested with that. So substantial justice is just out of question. You see, I'll tell you in the execution form, it prescribes the year of the case of execution, the civil court prison orders. What you read, huh? ये part 2. Consider execution go. What is that? ये part 1, part 2. Part 2 में forms है. Civil code rules and orders. I'm sorry, it's not there in this book. The forms are not there. Forms are available in part 2 of the civil code rules and orders. In that part 2, you have this execution petition format, where number 1, it is said that when is the date of decree, and whether there is another whether satisfaction is recorded. Now, satisfaction of a decree is required to be recorded under this form number 4. Just show it to him. Form number 4 is the form in which satisfaction is recorded. First page.
All this were carried out. It was the execution petition was filed on the as per the CPC provisions. The execution petition was allowed, and accordingly, only to enforce, only for enforcing under most probably under order 2025. Only the enforcing order was passed. Order was also given to the deputy commissioner. My lord, in that case, my lord, I may be just this case may be listed day after tomorrow. In the meantime, I will produce all the order copy.
It's not enforcement. This is a decree for execution. There is a DG land. And in DG land,
that decree was passed. Execution petition was filed.
Coming from the civil side, we use the term the execution of a decree for delivery of definite movable property. Correct. So enforcement, every decree is enforced, but the enforcement once we segregate it for under few heads, then we understand it better. So if it is a decree for execution of immovable property, in this case, by the order of the court, the police was directed and the deputy commissioner directed to have the execution done. Exactly the same thing I am telling you. It happened in West Bengal, and the Supreme Court came down very heavily on the execution being done after more than 2 years, that too without notice on the respondent. This notice to a respondent cannot be waived. We don't have a discretion to waive issuance of notice after this 2-year period. It's a mandatory requirement. Therefore,
that was carried out, Malad. Execution petition was a separate process.
In this order at WPC 141, passed by my esteemed brother, it's not done. Execution could not have been done.
That's why my actual submission is that this may be listed day after tomorrow or next week. In the meantime, let me collect all those information order copies, because I have already handed over those copies to the clients, because it was a bulky. We have been fighting this for the last 2 decades.
Okay.
Because execution was carried out, it was done as per law. Only enforcement person is here. Also, they have enforced it, but then they have done a superficial enforcement.
You see, that's the every decree has to be executed. Supposing you gave loan of ₹100 to somebody, you get a decree now. You have to execute it.
No, my lord.
So there's
our difficulty is we cannot on our own physical side, personal side, we cannot do it. It has to be by the authority.
We understand, but once the decree is expired, it has expired. Every
Sir, my
company-
responsibility decree is not, has not expired because the execution petition was filed. It was ordered to execute.
Satisfaction under this rule 4 is not there. Therefore, once it is closed, the end of the execution petition, it's not kept filed. Non-satisfaction is recorded in that provision only, alone. That keeps it live. Now, you see, you have a decree of rupees 100. I was giving an example. Against A. Before you could execute it, he fled away. You got reports from the police and all that he is responding. In that event, the court passes the decree of non-satisfaction and keeps it live. So therefore, whenever this man is caught, just like a warrant, just like when this man is caught, is found, he'll be arrested. It's a standing warrant where you don't have a time limit for execution.
So, in that case,
Appears to be so.
the clients would not have any protection. If the enforcing authority behaves in a different way, then what to do?
I won't say because I don't know what has happened, and therefore I won't say what has happened. Those orders are not before me. I would not comment, make a loose comment when I don't know the factual aspect.
My lord, here the decree was passed in my favor, and there was it's a question of two clans. And it was decided that instead of making too many parties, we'll say that only one will represent this and only one will represent this entire. Now that the decree was in my favor and the entire Digi land was to be vacated. And we tried, they did not vacate. So we filed the execution petition. And execution petition was heard, notices were issued, heard, and it was held that yes, this decree is liable to be executed. And for the purpose of enforcement, the deputy commissioner and additional deputy commissioner were given the responsibility. The deputy commissioner and additional deputy commissioner carried out the superficial eviction, and also in their decisions they have come to a conclusion that certain people they have been.
Mr. Patil, although you are making strenuous effort to tell us what has happened, but I have a difficulty in accepting anything which I can't read. If there's no decree before me, I will not understand.
That's why my response submission is this: let this writ petition be kept pending. I will bring all the records.
Okay. Just let me record that. Heard Mr. T. Patil and Counsel for the Petitioner, as well as Ms. R. Basal and Government Advocate appearing for the respondents. Next one. By filing this repetition in Article 226 of the Constitution of India, the petitioner has prayed for setting aside the minutes of meeting dated 22/8/2022 within bracket Annexes 6. And to declare that the letter dated, which page is that? 26 August?
26 August 2022.
Where is that?
In excerpt 7 page 32, Malad.
Okay, and to declare the letter dated 26/8/2022 within bracket Annexes 7 as null and void. So the petitioner has also paid for directing the respondent authorities to ensure strict compliance of the judgment and order dated 15/7/2022 passed in WPC 141 AP of 2021 dash Jornia, JORNYA, Ronya, next word, RONYA versus State of AP and others. Next one. Next one, the learned counsel for the petitioner pays for some time to obtain all the necessary and relevant records and to bring it on record by filing an additional affidavit. Next one. Few issues which has come to light on a perusal of the writ petition is that in connection with TS number BSR/TS-32/04, judgment and decree was passed on 27/12/2007, issued by the learned additional district judge, Basar, Eastern Zone, West Siang District. Stop.
Then my lord,
The
eligible.
record also it is also seen that the petitioner had filed an execution petition, which was registered as execution EXE full stop PET full stop number 1 within bracket BSR bracket close oblique 2013. Full stop. Thereafter, the decree was transferred.
No, my lord, it was disposed of.
Here it is written transferred. 18, page 18. Page 18, about line number 10, 12 from above. Thereafter, the learned court below transferred the decree for execution to Deputy Commissioner. So it appears that it also appears that the decree was transferred for execution to the court of a Deputy Commissioner cum District Magistrate, Daporizio, under whose jurisdiction the plot of land fell. Full stop.
He was directed to carry out, my lord.
Yes.
Not only transfer, my lord, it was disposed of and directed. Let's say next line it is mentioned.
It is not known as to how in what manner the said execution case was re-registered before the Deputy Commissioner, Daporijo. So moreover, there's nothing on record to show as to whether the court of Deputy Commissioner District Magistrate, Daporijo has been designated as a civil court and empowered to execute a decree. Next, be that as it may, the petitioner had filed a writ petition before this court, which was registered as WPC 141 AP of 2021, amongst others, praying for enforcement of the said decree. Accordingly, this court, by an order dated 15/7/2022, issued a direction upon the respondent authorities to carry out execution of the decree and hand over the vacant position of the DG land to the petitioner within a period of 6 weeks. Next paragraph. Apparently, the status of the execution petition is not available before this court. So, however, it appears from the letter dated 26/8/2022, issued by the Deputy Commissioner, Upper Subansiri District, Daporijo, he has categorically stated that the administration, inverted commas, the administration has carried out the execution of the judgment dated 27/12/2007, thereby evicted the respondents from the disputed land, basing on the judgment of execution of dated 14 July 2014 in execution petition EXE PET number 1 BSR of 2013, and completed the entire process within 6 weeks as directed by this court in WBC 141 AP of 2021, dated 15/7/2022, and accordingly, it submitted a compliance report. Thus, it appears that even if the Deputy Commissioner was executing the decree, he had recorded compliance of the decree, he had reported compliance and execution of the decree as on 26/8/2022. Therefore, the query of the court is as follows. Number one, whether as on date, any execution petition is pending, and if so, what is the number and the court where the same is pending. So number two, if due execution of the decree in connection with execution petition number 1 BSR of 30 is recorded on 26/8/2022, comma, whether any order passed by this court would be contrary to the provision of Article 136 of the Schedule to the Limitation Act of 1963. Next, in light of the provisions
ডাউনলোড করছিল ওটারও ডিসপ্লে মোৰ ইমেইলত আছিলে
just a moment. I'll pass orders in chambers, but there's a division bench. I'm sorry. Yes, sister, I'm sorry.
It's
I
okay.
forgot.
All right.
There's a division bench.
I saw her lordship.
I'm sorry. We will complete this bench and then.
Even my
Yes.
mobile all
Mr. Day, Mr.
My
Day,
lord. My lord.
In this matter, due to default on my part, the judgment could not be delivered within 3 months.
My lord.
So, the matter is to be reheard.
My lord.
But in fact, we have your notes. If you you just record the press hearing having been conducted and will pass orders today itself. Mr. Day,
My lord.
can we treat this matter as to be heard today and then pass deliver judgment?
Yes, my lord. My lord, only 2 points are involved here, my lord.
Yes.
The witness number 2, my lord, DW2 was examined. His evidence was not considered at all. Not a whisper has been made in the judgment.
There are two ways to look into it. Mr. Day, there are two ways to look into it. Number one, the witness of DW2 was not considered.
My lord.
But
And the Alvear report is blank.
No, that we have already that we don't find any merit, because if you're a foreigner and don't show any documents, then it can't be filled up. For that we are not with you. But in the for the first part, there are two ways to look into this aspect. Number one, in a writ of certiorari, you can also examine as to what prejudice you suffer because of non-consideration of that evidence, because on merit we don't find anything that in that evidence. That is an oral statement. She says that the brother says that he projected brother says that he is the proceeding is the sister, and
Yes.
exhibits a document. He says that exhibit 13, the sister could not give and he's giving it, but still it's a documentary evidence to show the relationship. That's one way of looking at it. And oral documents, non-consideration may not prejudice to you because there are many judgments on that point. The second part is that we can also look this as a case where, notwithstanding whether prejudice is suffered or not, but to maintain the judicial discipline, it goes back so that this proceedings case be examined.
My lord, another point I have taken, that is LBO report is blank, my lord. No reference could be made on
In
the
that-
basis of that
No,
LBO
in that-
report, my lord.
In that we are against you, because there are judgments of this court, and even going by paragraph 26 of Sarvanand Sonwar 1.
My lord, I have some latest decision, my lord, in this regard, my lord. Earlier, my lord, I have given some decisions, but
No, you have
another
given us-
Anjana, my lord.
No, but
it
you
is
see,
clearly stated, my lord, in Anjana Vishwas versus Union of India. And another one, my lord, Sushil Mandal versus Union of India.
but
That
those
is,
do
my
not,
lord,
but those do not overrule the Supreme Court judgments of Sarvanand Sonwar.
Sarvananda Sonal, my lord, discussed in the, my lord, Abdul Rahim cases also I have referred. In
But those are
Abdul
not-
Rahim cases, my lord,
Sarvanand
paragraph
Sonwar
37.
ratio of Sarvanand Sonwar
onwards.
was never turned down. So therefore, what happens is that if A is a foreigner and does not disclose any document of his nationality or residence, the police cannot fill it up. That's why the burden is on the proceeding. Please tell me, if you don't disclose me your address,
My lord,
proceedings under the.
I have filed an affidavit in reply, my lord. In my reply, I have clearly stated that no visit was, my LBO has not visited the residence of the petitioner, my lord. I have categorically stated in their written statement also, they categorically stated.
You see,
So, my lord, LBO report is not a report at all, my lord. The spot
Mr.
verification has not been done in this case.
Mr. Day,
my lord.
Let us test this.
My lord, so
now, let us test this. Your submission. Now, in a given case, today in this case only, correct?
My lord.
Let us say you are accusing A or B of not doing something in a manner prescribed. Correct? Can we decide that within the absence of the that LVO that he did not visit?
My lord, there is a my lord decision that is Sushil Mandal's case, my lord. It is clearly stated that if no valid reference can be made, if LBO report is no doubt, no reference. My lord, it is clearly but in the LBO report, no doubt is created against the petitioner, my lord, that she is the foreigner, my lord. So if there is no doubt created by the authority, my lord, so no reference could be made, my lord.
Mr. There are several judgments of this court.
In Sushil Mandal's case, my lord. My lord, may I pray, my lord? It may be hard in another date, my lord, so that I can, my lord, make my submissions, because it is too late, my lord. It was last heard on, my lord, 18/12/2024.
Yes,
So
yes.
may I pray, my lord? May I pray, my lord? This may be hard at land in another date, if possible, my lord.
Okay, sister will fix it after vacation.
Yes.
Okay, let's say that on the prayer made by Mr. P.C. Dale and Council for the Petitioner, this is the matter for further hearing after due vacation on a date to be fixed by the registry. Okay.
My lord.
Okay. I'm still continuing with the single bench, sir.
Yes.
Well,
Yes. इसमें जाएंगे। Okay, I'll get the decision later. I'll add it later on. Which color? Therefore, the court has a reservation. In this matter, though not returning that order dated 15/7/2022 was passed in WBC 141 of 2022. Can an execution process be initiated without by the orders of this court? Without giving any opportunity to the judgment letter of being heard. When admittedly orders for direction of execution was passed after 2 years from the date of the decree. And when the process was, or execution was transferred by a civil court to an executing court, being the court of the deputy commissioner come the district collector of the Upper Region. without recording satisfaction as to whether it is a civil court and competent to execute a decree. Full stop. Be that as it may, in the order dated 26/8/2022, the Deputy Commissioner, the opposition has recorded that the execution was carried out. But this would bring an execution process to an end. And therefore, revival of the execution proceedings having not been done by the executing court, would this court have competence to issue any further direction for execution without an execution petition being registered? And when the fresh process of execution would be much beyond 12 years from the date, from the prescription of Article 136 of schedule to the Act. Next, for these issues will be addressed by the counsel for the petitioner and matters next to list. Next, for list after due vacation on a date to be fixed by the registry. Oh, just record her presence, Ms. Basar, okay.
Obliged, Lordship.
Supreme Court judgment. Judgment. Yes.
May I please, Your Lordship? Lordship, just before my lord making submission, my lord, I was under impression, my lord, the tender of my lord whom the acceptance letter has been issued. My lord, that party has not been made as one of the respondent in the. So my lord, by handwriting, my lord, may I correct it, my lord?
Okay. On the prayer made by Sam Kato, the counsel for the petitioner, is permitted to complete the necessary party by submitting specially typed out cost title to the deputy registrar within the judiciary for being incorporated in the judiciary.
My lord,
Thereafter, the matter be listed again in the motion form.
my lord, matter may be, my lord, by allowing me to, my lord, correct it in the cost.
That can't be done. Now the High Court rules have been altered.
My lord.
There's a High Court rule which says that it has to be done by way of a fresh cost title being filed.
Then, my lord, in that case, my lord, since we are, my lord, placing urgency, therefore, my lord, matter may be listed tomorrow, my lord.
We've already ordered. Whenever you do it, it will come.
My lord.
Because today this section will not work now.
Yes, my lord.
Tomorrow, after doing it, you can bring it.
My lord. Deeply.
There's a High Court notification.
My lord.
That any amendment to the cost title will be done by way of a specially typed out cost title, because the central registry will have to be corrected.
Well.
Otherwise, in the certificate copy, the name of other respondents will never appear.
Much over.
May I please, my lord? My lord, amendment of respondent number 5 at NIT Jote. Your Honor, as per the recruitment rules, there are certain specified qualification that must possess by a candidate to be appointed as a associate professor in NIT. But Your Honor, that respondent number 5 name was not even recommended by the Board of Director or Board of Governor, Your Honor, Your Lordship. And moreover, respondent number 5 does not possess the teaching experience of at least 10 to 13 years, Your Honor, that too in national and state recognized institute, Your Honor. He was a teaching staff in private colleges since 2003 to 2019, Your Lordship. So having suspicion of this.
But we still can't issue a writ petition. You are not wanting to become a professor.
Yes, Your Lordship.
Are you a candidate to become a professor? No.
No, Your Honor, but I mean,
Service matters, you can't intervene. It's not at your instance, you can't do it. You must seek some remedy for yourself. A writ petition would be only maintainable when you can demonstrate your right. Then comes your fundamental right. Because infringement of your fundamental right is first. How will you be benefited? You have to show us that.
my lord, actually, I'm like.
You see, let us say that there are 10 people who were wanting to become professors. Correct?
Yes, my lord.
One was selected, 9 others were not selected.
Yes, my lord.
These other 9 are not agreed. People who have participated have not agreed. You're a young lawyer, we adjourn the matter, you be prepared. We'll take it up day after tomorrow. Minister, your name?
My lord. I also
Your
like.
name?
P. Wangpan, Your Honor.
P.
Wangpan.
Wangpan, then counsel for the petitioner. Yes.
Yes, my lord, I am for respondent number 2. I would also like to express that petitioner is, though I have not record now, as informed by my department that petitioner is working as UDC in PWD department. So he doesn't have any locus to initiate before this.
Putting him to a notice, he's a young boy, young lawyer, he has to, we are giving him an opportunity to address us. Correct. Today, we are not passing any adverse orders against him. The counsel for the petitioner, Mr. M. Patel and DSG appearing for the Union of India and Mr.
Up to G. Lolen. Z. Lolen.
D.
Z. Lolen.
G. Lolen.
Yes.
Counsel for respondent number 2. Next. On the non-counsel for the petitioner shall address the court. When his fundamental rights are not found to be violated, he is not the person who is an aspirant to the post of in NIT, Arunachal Pradesh. And when the other aspirants, the said post, have not challenged the appointment, why would this petition be entertained? At his instance. Next page. List of 10th, 10/4/2025. Be prepared on the day.
Much of.
Police.
Young blood must get a chance. Correct.
Yes.
Otherwise, it's completely type of PIL.
Huh?
PIL, it is
Whatever we were there.
or like
If we Stop them here. Yes. Okay, yes, contested motion. Yes.
May it pleases your lordship. Lordship, petitioner is aggrieved by the case being registered by the Human Rights Commission against the complaint being lodged by a private respondent, respondent number 10, lordship. Respondent number 10 has alleged that the petitioner has fraudulently obtained his voter ID and he is not a resident of Arunachal Pradesh. And with that regard, when initially she has lodged a complaint on 5/5/2023 before the authorities, before the 5 authorities, she has lodged the complaint.
Where is the notice issued to the petitioner?
Notice was not issued by the Human Rights Commission, lordship.
Then?
Notice, yes, lordship. Notice was only issued. What is her human rights violation? If we take up the Protection of Human Rights Act, lordship, I would like to section 2D of the Human Rights.
Section of Human Rights Act. Yes, what does it say?
Section, definition of human rights. Human rights means the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by the courts in India.
Yes.
Supposedly, if I say also that petitioner, for argument's sake, the petitioner has fraudulently. So what says her human rights violation, lordship? And if I would like to take lordship to section 25(1) of this act, lordship. 21(5), lordship.
First 12, then 21.
Yes, lordship. Section 12, it's a function and powers of the commission. The commission shall perform all or any of the following functions, namely, then suo motu A, B, C, and till J, all the powers and functions of the commission is there.
Now you are referring to 25. You are referring to section 25.
Section 21(5), subclause 5, lordship.
Yes.
Constitution of State Human Rights Commission, subclause 5 says that a state commission may inquire into violation of human rights only in respect of matters relatable to any of the entries enumerated in list 2 and list 3 of the 7th schedule of the Constitution. So if we see the 7th schedule of list 2, but the election, it comes to list 1, not list 2 and list 3. So jurisdiction, and as per 72, entry 72, lordship, read with list 1, entry 72 with regard to elections and all, lordship. And this provision also can be read with article 3 and 24(1). Lordship.
If no notice is issued, then how,
So that notice is being given by the ERO Lordship.
where is that?
That notice Lordship is at page ERO's notice to the petitioner. ERO's notice 76 Lordship, 76 and 77 Lordship. ERO has given him notice.
76.
Yes, Lordship.
But you see, once electoral registration officer issues a notice,
Yes, Lordship.
that would be within jurisdiction because the electoral registration officer has a power to do it.
Based on the complaint, if we see, and the direction, because order of the Human Rights Commission also is there, Lordship.
He appeared in person on so and so with documents. Enclosed Human Rights Commission. Where is that order? Human Rights Commission.
And written as enclosure, we are not being, because we are not party to that, Lordship. We are not being provided with that.
No, but in this page 76.
Yes,
These
Lord.
are the two documents which are enclosed.
And no.
Your Lordship, my query is page number 75, Your Lordship.
75.
Yes, Your Lordship. This is notice to the district electoral registration officer from the Human Rights Commission. Your Lordship.
Human Rights Commission has issued notice to the ERO, Lordship. Similar matter also is pending before this Honorable Court, Lordship, item 50, wherein this Honorable Court has stayed that proceeding before the Human Rights Commission.
Yes, Your Lordship.
No, process of Human Rights Commission is one part.
Yes,
But
Lordship.
the ERO's action, that is protected under the Registration of the People's Act.
Yes, Lordship. We have complied with, we have filed reply and before the ERO, we have done that, Lordship. And even there is a report also, which is annexure 13, Lordship, from the additional Superintendent of Police, Special Branch, after making the inquiry to, this is being addressed to the Superintendent of Police.
But then, Mr. Ram, this proceeding before the Human Rights Commission has to be stayed.
Yes, Your Lordship. Because this bench only, Your Lordship, in other item number 50, they have already stayed the proceeding, Your Lordship.
Because we are not being served with any copies or even any documents of the Human Rights Commission's case, Lordship.
You're not being supplied copies.
No, Lordship.
Where is the statement?
Because we have not been sent any notice. We have been sent notice by the ERO. We have complied with, we appeared before the ERO. We have submitted all the documents. Our reply also before the ERO, Lordship. We had submitted our written reply. Dated 28/2/2025, page 81.
Okay. This is D Ghosh and also for the petition. As well as Mr. Y. Ram, and government advocate appearing for respondent numbers.
1, 3, 4, 7, and 8. 7, 8, and 9.
4, 7, and 8.
9 also, Your Lordship.
1, 3, 4, 7, and 9. No, not 3.
Yes,
You
Your
are
Lordship.
not appearing for 2, you are not appearing for 3 also then.
No, Your Lordship, 1, 3, 4.
No, 3 is a chairperson of Arunachal Pradesh. If you are appearing for 3, then you will have to appear for 2
No,
also.
no, here it's different, Lordship.
Here, Your Lordship.
In this case, that is item 50, I think,
Oh,
Yes.
Lordship.
Okay, 1 and 3 to 9.
Yes, Your Lordship.
Next, brother.
No, Your Lordship. 5 is the Election Commission of India, Your Lordship.
5 is?
Election Commission of India, Your
Oh,
Lordship.
not 5 also.
Yes.
5, Mr. Kato will be there.
Yes,
He's not here.
he's not here, Your Lordship.
Will it be for 6?
Just somebody may go and just check out if Mr. Kato is there.
I'm sorry, Your Lordship. 1, 3, 4, 7, 8, and 9.
1,
5
3,
and
4,
6.
7, 8, and 9.
Yes, Your Lordship. 5 and 6 are.
Okay.
8 also.
Yes, brother. Mr. Kato, this election commission will be appearing.
Election commission, no, my lord, election matter.
No, not election matter. As a election commission of India.
My lord, in all election matter, Mr. The A Apang is appearing in other cases.
No, he is for state. This is
For center also, man.
Huh?
For center also, man.
For central also.
Yes, man. There was one issue, like, my lord, EVM machine has to be, my lord, deposited by the.
No, not that. This relates to.
There was direction from the ministry, election commission, that he has to appear in the entire election matter on behalf of the election.
But this is not election petition.
My lord.
This is not election petition.
In that case, my lord, I'll take the instruction.
Mr. M. Kato and DSJ for respondent number 5 and respondent number 5. Mr. Howard, he has also admitted that in certain cases, the election commission also appoints, has also appointed another senior counsel as their counsel on record. So therefore, submits that. He would take instructions whether to appear for respondent of 5 or not. Correct?
Right.
Don't say he appears for you. We just say like this. Mr. M. Kato is available in court. Was asked to represent respondent of 5. Mr. Howard, he has submitted that. Then add this. Okay. Next, brother. The case of the petitioner is that. Which page is that notice you got?
Page 76, Lordship.
Case of petitioner is that she has received notice from the electoral registration officer, 49 Bordumsa, Diun, Assembly constituency, requiring the presence of the petitioner to answer the proceedings arising from proceedings which is registered on the basis of a complaint filed by respondent number
10, Lordship.
10, alleging that the petitioner had obtained his voter ID card and electoral photo identity card fraudulently. So it is submitted that the said notice contains a reference to the reminder notice dated 3/2/2025 issued by the Arunachal Pradesh State Human Rights Commission. Full stop. Next paragraph. On a perusal, no, it is submitted that the said notice dated 3/2/2025 reveals that the commission on receipt of the complaint by respondent number 10 had directed to took cognizance of the directions issued by the Chief Electoral Officer of the state, by which direction was issued to the District Election Officer, Changlang, to take appropriate action and alleging non-compliance, the Commission had taken cognizance of the matter under section 12 within bracket A, bracket close within bracket small Roman 2 of chapter 3, Roman 3 of the Protection of Human Rights Act of 1993 and the Electoral Registration Officer, Bordumsa, directed to submit an action taken report. Failing which the said authority was threatened of coercive steps under section 13 of the Protection of Human Rights Act, 1993 by calling for his personal appearance before the commission. Full stop. It is submitted that as per it, as per petitioner's instructions, the petitioner has not received any communication from the Human Rights Commission for participating in any proceedings registered before it. So it is also submitted that the steps, the voter ID card, the electoral photo identity card, and the photo ID card relates to the action taken by the authorities under the Representation of the People's Representation of the People Act, 1951, and the conduct of election is covered by list 1, entry number 72 of the seventh schedule to the Constitution of India. So accordingly, comment is submitted that the action which has been taken or initiated by the Human Rights Commission from Arunachal Pradesh is to divorce the statutory powers conferred under Section 12 of Chapter 3 of the said Act. As under because under Section 21 within bracket 5 of the said Act, a state commission is empowered to inquire into violation of human rights only in respect of matters relatable to any of the entries enumerated in list Roman 2 and list Roman 3 of the 7th schedule to the Constitution. Of India. That's why we also submitted that similar steps taken by the Arunachal Pradesh Human Rights Commission have been challenged before this court by filing WPC 105 AP of 2025 and WPC 133 AP of 2025. And this court, in both the cases, stay was there. Both the cases.
Yes, both the cases stay.
And both the
I can provide
petitions
one case is also.
by virtue of order dated 13/3/2025, passed in WPC 105 AP of 2025, and order dated 28/3/2025, passed in WPC 133 AP of 2025. The proceedings before the said commission was stayed.
This is of another writ petition. Lodge.
It's okay. Two and next one. You should notice returnable on, give a date after 5 weeks. Also and so. The extra copies of the writ petition be served on the learned government advocate as well as on the learned DSGI in 2 days. So how the learned DSGI is at liberty to obtain instructions as to whether you would be appearing in the matter for respondent number 5. Next, the petitioner shall take steps within 2 days for service of notice on the respondent number
2 and
10.
2.
Sorry, 2
2 and 10.
2 and 10 by the District Court PGD. The test takes within 2 days. So the learned counsel for the petitioner is at liberty to collect the postal receipt number and to submit postal tax report prior to the next date of listing. Next paragraph. On a this is say the prayer for interim relief made by the learned counsel for the petitioner is opposed by the learned DSG and as by learned government advocate. Next, our privacy satisfaction that obtaining of a voter ID card does not adversely affect the human right of respondent number 10. The court is of the privacy view that the Arunachal Pradesh State Human Rights Commission lacks jurisdiction in entertaining such complaints. And issuance of ex parte notice, ex parte direction on the electoral registration officer without hearing the petitioner expressly appears to be violation of the human rights of the petitioner. So therefore, further proceedings by the Arunachal Pradesh State Human Rights Commission in the matter relating to complaint by respondent number 10 being case number APSHRC, that is page 75. It's copied from there. So and so dated 3/1/2025 shall stand stayed till further orders. Next para, having noticed that already there are 3 matters on board of similar nature, the court is also inclined to issue notice on the respondent number 2 to show cause as to under which provision of the Protection of Human Rights Act, 1993, empowers the State Commission to accept a complaint of a fraudulent obtaining of a voter ID card and under what provisions under list 2 and 3 of Article 7 of Schedule 7 to the Constitution of India, according to the said commission, a voter identity card is issued. Next, the pendency of this petition shall not be a bar for the Arunachal Pradesh State Human Rights Commission to examine the matter and to drop the proceedings against the petitioner, is so advised. Next para, the list on 14/5/2025. All the facts are listed on the same day.
Lordship, then item 50 also may be listed on the same day.
Same day.
And interim order in item 50 may be continued.
50, okay. Item 50. Positive matter could not be, both sides are represented. The positive matter could not be taken up today. Don't say both sides. We don't know about others. You say petitioner, the Union of India and the state respondents are duly represented. Positive matter could not be taken up today. List on same day, 14/5. Item 6. Huh? 6 also. Same. Same day. For other matters, I don't think I have time.
My lord, item 13 to
Serious matter.
series method, that was only for segregation, my lord. Because some matters have been unnecessarily taken together.
Okay.
So I have, as per the last direction, as I was supposed to convey this honorable court, which matters has to be segregated.
Please tell us.
My lord, item 13 to 21 are analogous.
13 to
21.
21. Okay.
These are against fact finding committee and the recovery drive. Then 22 and 23, these are totally different matters. 23.
Yes.
Then 24 is a separate individual matter, my lord, for claiming damages. And 25, 28, 29, 30, 31, 32, 33 are for solution, my lord, claiming solution, my lord.
Solution. So
Yes.
it will be treated differently.
Differently.
Item number, please tell again. Item
My lord,
numbers.
item number 25, 28, 29, 30, 31, 32, and 33. This will be, these are for solution.
These are for solution. Item
Yes.
number 22 and 23 are for
These are different,
different.
22 and 23 different stretch of roads, my lord.
Separate stretch of land.
Land, my lord.
And basically, my lord, against the fact finding committee, my lord.
Against fact finding committee only. That was like, but that is different, lord. Different.
My lord, here I am the court of petitioner. My case is, my lord, only.
I'm segregated. 26 also is a totally different matter, my lord. It's for payment of
24 and 26.
no, only 26. 24 is altogether different, my lord. That is also for payment of compensation, but for damages while executing. Then 26 also is different, my lord.
Yes, respective counsel for the petitioners, they agree to that.
Yes.
They segregate these matters.
And 27 also is different, my lord. These are separate.
27.
24, 26, 27, all three are separate, my lord.
Okay.
34 is
Give me some, give me an order where these were clubbed together. Can you recall which is the order by which all these had clubbed together?
my lord, earlier orders, my lord, I was not there, my lord.
Okay. We have that. We got that order. 11/12/2020.
Yes.
Is that order?
Yes, maybe.
Uh,
And 34 is totally different, my lord. It's regarding Rajiv Gandhi University, nowhere connected, my lord.
Okay.
36, 35 can, it's also for solution. This can be along with item 33 or.
Okay.
Yes, my lord.
In this
That's
group, from item number,
Item number 13 to 21 will be analogous.
no. This group is from item 13 to
13 to 21. This is
No.
total item 13 to
items.
35.
35.
Yes, ma'am.
In item 13 to 35, pass a common order. And the photocopies, keep it in all files. Huh? Say the learned counsel for the petitioners of all these matters are present. The several respondent authorities are represented by Mr. N. Ratan Lanet, Additional Advocate General. Mr. You are also there?
No,
For state?
I am in item, no.
No, state. Mr. Long, you are for the state? And whatever, you are for the state. Okay, Mr. and Long Lanet, Additional Advocate General, Additional Senior Government Advocate. Anyone else for the state? No.
No, not.
Oh, no, I'm asking the state. Oh, I'm sorry. Only you are there.
Yes.
Okay. For the state response, the bank. Under the next para. The Learned Additional Advocate General, by referring to the order dated 27/3/2025, has submitted that that he was required to address this court as to whether whether some of the some of the repetition in this batch are not connected and whether they are required to be segregated. Next para. It is submitted that he has gone through the records and he has found that insofar as repetition numbers, now you item 13 to 21. You have to give the repetition numbers. Item 13 to repetition. Are the repetitions arising out of the fact-finding committee report?
Challenging the finding report as well as recovery drive.
Which is under challenge, and the recovery notices issued are also under challenge. So accordingly, it is submitted that these matters can be taken up together. Next paragraph. In respect of WBC number, this would be 22 and 23. It is submitted that although this repetition is against the finding of the fact-finding committee, but the land area is different from the above referred cases. So accordingly, it is submitted that these two matters be taken up separately. Next paragraph. In respect of WBC, so item 24, the subject matter relates to the claim of damages arising out of the execution of the land acquisition notifications.
No, execution of the road.
Huh?
Damages caused during the execution of the road.
Execution of
The road.
execution of
Road.
Achha, road. Achha,
Yes.
execution of construction of road. So accordingly, it is submitted that this matter be taken up separately. Stop. In respect of WPC numbers so and so, that will be item 25, 28, 29, 30, 31, 32, 33,
and 35.
It is submitted that the claim relates to that this repetition relates to the claim of the petitioners for solation. Accordingly, it is submitted that these matters be also taken up separately. In respect of WPC numbers, that will be item 26, 27, and 34.
No, 26 is totally different.
That's what I read.
25, 28.
25?
25, 28, 29.
25 you already dealt with.
Yes, ma'am.
Now we are on 26, 27, and 34.
Yes,
It is submitted that these matters are unconnected
yes.
and does not relate to the fact-finding committee report or recovery of excess compensation allegedly disbursed. So accordingly, it is submitted that these rate petitions be taken up individually and separately. Next part. The learned counsel for the petitioners agree to the submissions made
My
by
lord,
the
item 34 is also totally different. Ma'am. This is with regard to Rajiv
We
Gandhi.
have already ordered.
Yes, sir.
So the learned counsel for the petitioners agree to the submissions made by the learned advocate, additional advocate general. Stop. Accordingly. Next for accordingly. That the rate petitions rate petition numbers, the WBC numbers, the item 13 to 21. You copied from first. Item 13 to 21 shall be clubbed together and taken up as a batch.
28 to 20.
And the other matters will be also grouped separately as indicated herein before and be listed separately. Unconnected with this rate petition. The batch of this this 99 rate petitions. Okay. When should we list it again?
My lord, after the break, my lord. May 13. 13 May.
Okay. This one 13/5/2025. So insofar as the unconnected matters are concerned, the registry shall fix the matter. After 3 weeks on a date to be fixed by the registry. There's one group of 13 to 21, we are listing it on 13 when we are saying. Other matters will be listed after 3 weeks on a date to be fixed by the registry.
Yes.
All other matters. Okay.
Otherwise, can it be preponed, my lord? 13.
Let it remain because we have difficulty. After vacation, all cases are being rushed after vacation. Registry will be in difficulty. Tomorrow will it not be happening. The already the registries the registry the listing sections are all closed. Now it can be day after tomorrow.
My lord,
Just a moment. Somebody is speaking. Yes. Correct.
because there is the enforcement going, where is this order, already past order, it's taken.
48, 49.
48 and 48.
My lord, in
List on
49, I was appearing for the petitioner. My junior, he is not available today. And copy is being served to my other junior today. They want to file objection, my lord. Earlier, I used to be for the petition order. In item
49.
49.
Who wants to file objection?
Now,
You're free.
In item number 48, for respondent number 4, my lord.
Item 48.
Yes, my
You're
lord.
respondent number 4.
Yes,
he is the petitioner in item 49.
49.
Or passing status order. Because already they registry order, even when they are enforced, forgotten.
My lord, that will create trouble.
I don't know, but once he is asking for time to file affidavit in opposition, how many days you will file it?
After break, maybe.
What fixed it after break?
Give a date when Mr. Tabak is asking for a early hearing.
The construction is going over my, that is the issue. Whereas stay order is there, even when they are violating.
No, violation will be dealt with when you file a contempt.
That is right.
My lord,
They will take instruction where their client are compliant at order. That is there. I can close the.
Okay, item 48, there is an IA.
49 has to take with the 48, whereas 48 is the my.
It is, let me pass an order. In item 48, you say, who is the, what is this IA? Item 48, what is the IA? What is the IA for?
Passing status quo order. Over the land. Because they are encroaching over my land. Where execution order has been already passed over the Kavang decision. Over the land dispute. There is a, I have encroached the court order. State that proceeding. There is a history order.
Where is the connected date petition to this A95? Which is the connected date petition? No. This IA is in WPC 53 of 2020.
yes, my lord.
Where is the date petition? नहीं, इसके साथ
I
53 कहाँ है?
WPC number 53 of 2020. I has been filed over that. This order dated is enclosed, stated this decision of the Deputy Commissioner. Page number 33. This honorable court has already passed the interim order, saying that part of
Just wait,
proceeding,
just
part
wait.
of proceeding is illegal.
Please wait. In this IA, where is your statement that that this order which was passed on 11/2/2020 was served on the Deputy Commissioner?
Kindly see this, page number. I have enclosed the execution petition, execution order, so. This is the impleadment.
Mr. Tapak,
Yes.
you have understood the query? What was the query? Please repeat. What was the query of the court?
Page number 26.
26.
Deputy Commissioner has directed that circle.
Can you please respond? What was the court query to you? What did I ask you? You are responding to something. You must have heard me and then you are responding. Or you are responding irresponsibly. I have asked you a question. I have asked it twice. And what did I say and what did you hear? I'm asking you to repeat it. This is being repeated by me for the third time. The court has put you a query. Did you hear it? Did you understand the query and then start responding? Or you're acting irresponsibly? Mr. Tapak, please don't make me change my character. I've asked you a question and the question was asked very politely. For the third time, I'm asking that question. You got an interim order in the writ petition on 13/2/2020. Please tell me in your this IA, have you said that a certified copy of that order was served on the deputy commissioner and on what date?
Lordship, that is why, Lordship, I have already said that that is connected, that is Devon decision, Lord.
You'll be digging your own grave in this case by not responding. Now I'm not hearing you. Now I'm not hearing you. This is something which is inexcusable. You are acting irresponsibly. In this interlocutory application, the prayer is for directing the for injuncting the respondents so as to maintain status quo ante over the disputed land. Mr. T. Tapak, learned counsel for the petitioner, has submitted that an interim order was passed in the connected writ petition on 11/2/2020, by which a direction was issued to the for stay of the operation of the notice dated 30 January 2020, issued by the circle officer, BILAT, which was stayed till further orders. The learned counsel for the petitioner submits that the respondent number 5, who's making the construction now?
Respondent number 5.
Respondent number 5 is carrying out construction illegally over the
House construction is going.
house construction is being carried out by respondent number 5 over the disputed land. Next, on a perusal of the notice dated 30 January 2020, the operation of which was stayed by the order dated 11/2/2020. It appears that in connection with execution case number 1 of 2013, the persons named therein, which includes the petitioner, were directed to appear in the execution proceedings. Stop. Where is the Kabang decision which is put to execution by notice dated 30 January 2020? Can anybody respond? What is the Kabang decision which has been put to execution? Is that Kabang decision at page 17? Therefore, the writ petition merely challenges a notice issued by the circle officer and there's nothing in the writ petition to show that that there is any declaration by any court of right title and interest of the petitioner over the land in respect of which this interpolated application is filed. First one, in the connected writ petition, it is projected that the command decision was to hold that the command decision dated 10/5/2012 was merely to declare that the other party had sold the land illegally. Full stop. Therefore, it is not very clear that what decision of the command was sought to be executed. So this next the query of the court to the Honorable Counsel for the applicant was what was the query? What was my query which was not responded? The query of the court to the Honorable Counsel for the petitioner is that whether order dated 11/2/2020 passed by this court in connected WBC 53 AP or 2020 was communicated to the concerned circle officer. Despite the question being asked 3 times, the learned counsel for the petitioner applicant did not assist the court in giving a straight answer. Full stop. I'm again asking you another question. Where is a copy of the decree which is put to execution? Where is that decree? Where is that decree which is put into execution?
Pardon, Lord, sir.
Where is the decree which has been put to execution? Where is that final order?
That is why I wanted to draw the attention of this honorable court. That is the Kabang decision also.
In Kabang
Customary
decision, what is,
Kabang decision is page number 16, annexure 1,
yes,
passed by the village authority.
yes.
That authority, competent authority to execute that Kabang decision is the deputy commissioner. Deputy commissioner has already executed
what
the
is
Kabang
the-
decision.
What is the operative part of that Kabang decision which is put to execution?
Kindly see, Lordship. Execution order is, I have enclosed page number 25. Page number 25 of my petition. Kindly see last paragraph.
It doesn't take you anywhere.
Last paragraph, Lordship.
It doesn't take you anywhere.
Yes.
If you
Page
don't
number
respond to the court query, it doesn't take you anywhere.
Yes.
You are on a train which doesn't move.
Page number 25, Lordship. Last paragraph. This is the operative portion of the execution order of Kabang decision. The execution case number such and such is then disposed of with a direction to degree holder to possession and occupation of the land in question or to restore the possession if disposed. Copy of the order. Be
Please
furnished
come to
both the
page 20.
Parties.
Please come to page 20, which is the type copy of Kabang decision. What is the finding of Kabang? There are only two findings. Number one, the Kabang observed that G. Mayong could not give any proof of his claim over the land. So he has been directed to return the money of so and so, and has been treated as mistake out of ignorance. Number two, the members present in the Kabang observed that by making a complaint, the Talo family done a good thing of preservation of established custom. Now, where is a finding by the tribunal or this Kabang to evict villagers and to put into execution?
Kindly see page number. May I reread this contents of
the
Kabang decision? Page
Yes,
number
I have read
20,
it, but
annexure
you are
1.
not assisting us.
Yes.
So I'll read only what I want to read.
May I read the contents, Lordship?
Definitely.
These points, there are 2 points. Decision for point for decision is there was 2 points.
Now, please tell me.
Yes.
If tomorrow you are asked to give us the give us a gist of the decision taken in Indra Sahni case, what will you do? You will start reading for 10 days.
Lordship, I am to say.
Mr. Tapak,
In
every statement you make,
Yes.
it makes me feel that it is unnecessary to debate with you. You are to engage with you in any conversation. The decision of the Kabang is number 1 and 2, which I have read, and you don't want to read it. In a judgment, there may be hundreds of things written. Do you know the basic concept of an dicta and an obiter?
Page number 20 is Lordship, when I am
In the writ petition,
IL interlocutory application, Lordship.
Mr. Tapak, I am sorry to tell you that elementary knowledge of procedural law is not available with you. What is a obiter? What is a dicta? You don't know. You are reading every part of the judgment, but you don't read the decision taken.
Lordship,
You are intentionally avoiding the order of the court.
I am reading the Lordship, interlocutory application, Lordship.
You take risk. Every time you annoy the court, you take a risk. And you don't even know what is going to come. If you don't assist me, I am equipped to read English. You are cutting out a sorry figure before the court. And it is not only one case which will haunt you. I forgot a sin. I don't carry dead bodies home. But I have a principle, I don't forget a sinner. I forget and forgive a sin. I never forget a sinner.
English version is.
I can recollect Whenever I see you, I'll recollect what has transpired in court today.
English version is page number 23, Lordship, annexure 1.
We don't want to read anything. If you give me a judgment of Sindra Sani to read, I know how to read it.
I will try to, Lordship, collect. I do not know that Inter-Sani is like.
I am not on Sindra Sani judgment. You know what big judgment? Any lengthy judgment you know of? Any lengthy judgment you know of the Supreme Court? There are hundreds of reported cases in Supreme Court which run into hundreds of pages. Can you recollect any one name?
No.
No. So how do you read a judgment? It is the dicta which is being always first read. When you read my order, after I pass this order, first thing you will go home and read the last part, what the judge has ultimately given us. And then you read the entire judgment. So please don't compel me to read whatever you want to show us. In the judgment of the Kabak decision at page 20, there are only 2 paragraphs of direction. Any of these 2 directions give you right title and interest or to vacate, have the land vacated? No, then the execution proceeding is bad.
Lordship,
If the execution petition is bad, then this writ petition also is dismissed. You don't know about the consequences which come. And we have to think of of your client which is behind you, of whom we don't see. And you don't assist the court in telling us the correct state of facts. Even before you open your mouth, we know what is there in this matter. And therefore, thereafter, we are asking you. We are giving you an opportunity to represent your client in a proper manner. But you're not doing so. Had we not noticed your client behind you, we'd have dismissed it right now. And you still don't assist us. So you see the consequences. Stop. Next paragraph. The court had requested the learned counsel for the petitioner to address the court as to the directions which is contained in the Keba decision. Stop. He refuses to read the directions contained in the English version of Kabak decision at page 20 of the writ petition.
It is 23, Lordship.
And
I've enclosed the 23, not 20. It is the Kabang decision, Lordship. Kindly see. Any adverse that such type of adverse order may not be passed against me.
not even you, we are referring now this, after showing us page 23, we are referring it to the bar council, whether you are fit to be a lawyer, whether you are responsibly acting against in respect of the court.
Lordship, very sorry. I am trying, Lordship.
You are trying to read page 23. 23 is to Deputy Commissioner, a letter to Deputy Commissioner, prayer for review. You are reading this before the court
Lordship,
and saying that this is a Kabang decision.
Kabang decision is in page number 23, Lordship.
23 of the writ petition.
Yes, no, not in the writ petition.
Yeah, we are in writ petition. We are
I-
asking you writ petition time and again. We are asking you come to
I'm
page
reading the
20.
interlocutory application, Lordship. I'm on interlocutory application. Not in the.
Don't force me to change my character.
That is why, Lord. My Lordship, page number.
This is going to be link. You have to go to Guwahati, I think. Please proceed.
Yes, page number 20 in the writ petition, Lordship.
Page 20.
Page number 20 in the writ petition.
No, it's okay. 23. We are there at 23.
20.
Yes, at page 23.
Yes, not
Wait.
in the IA.
It's
it is
okay.
page
We are
number
reading
23.
IA now to page
In the
23. In page
writ
23 in the
petition, page
IA.
number 20.
Okay, that's the
Yeah,
same
that
thing.
is right.
It's same thing. But come to page 20 or 23, whatever you want. We are asking you for the 4th time. What is the operative decision of Kabang? Will you assist us?
Lordship, I have to know what is exactly which petition is.
I am
reading,
extremely
Lordship.
sorry.
Lordship,
I'm
I
extremely-
need to catch the Lordship, which petition is going on, Lordship.
We told you either read page 20 or page 23, whatever you want. And please tell us what is the gist of the directions contained in the KEBA decision.
Yes, page number 20 in the WP.
Yes, please read that.
There was a 2-point, Lordship. Kebang observed that this line goes like this. The Kebang observed that G. Moyong could not give any proof. This is my opponent at that point of time, before the Kebang. His claim over the land, so he has been directed to return the money to Siram family who has purchased the land forthwith. And the act of Gobang Moyong has been treated as mistake and unintentional act of ignorance. That is 1 point. 2 point is, members present in the Kebang observed that by making a complaint, the Talok family done good thing for preservation of the established custom and uses of the village by supporting the complaint. The Kebang has decided the case in favor of Talok family. I am the Talok family also.
Correct. And where is the order to vacate the land? Where is the order to the respondent to vacate the land?
Lordship, this respondent was, this is one of this Z Talo, this Gyan Talo, he has filed letter after 7 years, Lordship. He is not in the party, not a party in the Kebang decision, Lord. This respondent. This is the case here, position of the case here, Lordship.
My lord, may I assist, my lord? Although.
No, this is beyond repair now.
Yes.
Yes, my lord, what happened?
No, this is beyond repair now. You see what has happened. He is being given a notice to appear in an execution proceeding. In an execution proceeding, there must be a decree, correct?
Yeah.
Or an order, which is enforceable as a decree. Kebang decision is enforceable as a decree, correct?
Yes.
Now we are asking him to read page 20, which is the Kebang order.
Yeah.
And this order does not say X, Y, or Z vacate the land.
Exactly. It itself holds that the land belongs to Talo family. Now Talo family, my lord, he represented the Kebang as a president of the Talo family. Thereafter, he individually filed an execution petition in his name before the deputy commissioner. Kebang decision at that point of time was not
Execution petition for what?
Execution petition of the Kebang decision.
Correct.
That was also before the deputy commissioner, which
Correct.
he did not.
That's what we are saying. Kebang decision is at page 20.
Yes, ma'am.
Can execution go beyond the order?
Yes, my lord.
Correct.
Yes, ma'am.
So that's why whenever you stand up, we say that he has got no basis. And
No
that is
basis.
perhaps he is not responding to the court query.
First of all, there is no basis of execution of that Kebang decision. Secondly, he went to the deputy commissioner.
Mr. Tapak, I have a relative. When you ask him, he will respond to everything. But when you ask him that you took 100 rupees on that day, please return, then he will say, He will not hear. If he has borrowed something and then you want to return.
I was reading the interlocutory application, that is why.
Whatever you
He
read.
was reading the
But the Kebang order, we are asking you time and again of Kebang order.
There is a
And
miscommunication.
this is what you are there. So not only your IA is being dismissed, your writ petition also goes now. That is the difficulty if you don't assist. It's too late, we'll pass an order in the chambers, but we are dismissing your writ petition and we are also dismissing your interlocutory application. Both are being dismissed.
And what about connected writ petition also?
We don't know about connected writ petition, we have not applied our mind. Insofar as this order
There
concerned,
is
you just
a stay order in the connected writ petition also.
Oh, okay. Just continue this order. I'll you type it out, then I'll sort it out because I have forgotten the sequence. Next. From the contents of the so at this stage, it would be appropriate to reproduce the contents of the KEBA decision. It's at page 20 in the writ petition, 23 in the IA. Next paragraph. Therefore, comma, on a perusal of the KEBA decision, comma, there are only two directions, and none of the two directions contain any decision of the KEBA directing anybody, any party to the proceedings to vacate the land. To stop under such circumstances, I mean, we don't find any reason for the execution proceedings to have been registered. First of, there is no decision at all for enforcement in the KEBA decision dated 10/5/2012. First of, next paragraph. There is nothing on record to show that the petitioner has asserted his right over the disputed land, and therefore prayers for injunction in an injunction of the stay in an interlocutory application must necessarily be in aid to the primary relief claimed in the writ petition. Next paragraph. Therefore, comma, when the petitioner claims his rights to have accrued from the KEBA decision dated 10/5/2012, which does not declare the right title and interest of the petitioner, no case is made out by the sorry, it will be applicant always, for the applicant for an interim order in his favor in this interlocutory application. So accordingly, comma, as prima facie title could not be shown in favor of the petitioner from the KEBA decision dated 10/5/2012, comma, the petitioner has not been able to make out a prima facie case for an interim order. Stop. Therefore, comma, the balance of convenience for an interim order is not found in favor of the petitioner. Stop. Next paragraph. Accordingly, comma, in light of the discussions above, comma, the court does not find that the petitioner would suffer any irreparable loss and injury which cannot be compensated in terms of money. Stop. This next paragraph. Accordingly, the court does not find this to be a fit and proper case to pass any interim order in favor of the applicant. So according to this, interlocutory application stands dismissed. Your name I did not record.
No, I'm appearing on behalf of Kerala.
Your name?
P. Harming.
P.
Harming. Harming. Harming.
Harming. Harming. Then counsel appearing on behalf of
K. Lawyer.
Mr.
Private
K.
respondent number
Mr.
4.
K. And counsel for respondent number 4
Yes.
is present. Okay. If this to adjourn it. This after saying the vacation on date to be fixed by the registry. Mr. Prabha, please respond whenever we ask questions, respond to the court query. It doesn't take you anywhere.
Very sorry, Lordship. I was reading the another.
No, it's not a question of this 20 and 23. That's a small issue. But we have been asking you questions time and again, and you are not responding it at any position and any issue. You make your deliberations as if you are a tutored parrot. You can say nothing more. It's not good. We ask you questions deliberately. When we are taking up matters till 6 o'clock, we expect you to cooperate with the court. If you have not understood what I'm asking you, please ask for 10 times. I am never annoyed with that. It doesn't take you anywhere when you ask a pointed question, you give a different answer. It doesn't take you anywhere. Ultimately, it's a decision-making process and the authority to take decision is with us. So please respect that we are asking you questions. It's not that I have behaved in a inappropriate manner before you. It's not that I have addressed you in a non-befitting manner. Then why do you provoke us to make observations? It's demean you in front of so many lawyers. We don't intend to put personal aspirations against anyone. But you are compelling us, you are almost putting up your finger in my throat and asking me to shout. In this tone which I have addressed you today, have you seen me for last 8 years in this tone? From the day I joined and I am coming to this Itanagar bench, have you found me shouting in a loud voice? No. Then it's not that I don't know how to shout, but I respect all the counsel here. I've never misbehaved. I think I've never misbehaved with anyone. To my best of my knowledge, I may be wrong. I don't know horribly. But to my knowledge, I have not spoken in a high-pitched language to anyone in this esteemed bar. I'm the first man today I had to shout. I don't like changing my character, but if I do, it will not be good. Because I can assure you, yesterday also I said, today I'm also saying, I can be more prepared than you any given day. So don't provoke me to pass orders. Something I dislike. I have to think for a client which is behind you. It's not only you alone who suffers because of this outburst. It is someone who is behind me whose face I don't know. That faceless person suffers. And this should never happen. In no case I desire to pass an order just because I've lost my cool. But I've taken a very conscious decision. I've thought about many times. Then I found that when there's no order of Kebang to take an execution, to evict someone else, you can't stop his construction. You assert your right in an appropriate manner. And therefore, I had to pass orders. I take a conscious decision, not with a heated mind. I can assure you that. The mind which was exercised was a judicious exercise of mind.